Good morning, all. This case management conference and application hearing is in the matter of CFI 041-2021 and is being held by way of video conference before Chief Justice Wayne Martin, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Simmons & Simmons. Lead counsel is Mr. Ben Hubble and Mr. Daniel Edmonds. The first defendant to third defendant are represented by Altonini and Company. Lead counsel is Mr. Justin Fenwick, KC, and Mr. Tom Montague Smith, KC. Thank you, Chief Justice.
Good, thank you. Thank you, gentlemen. Has there been any discussion about the order in which we'll deal with the matters? Because there is a case management conference and, of course, there's an application for immediate judgment and or strikeout. Which is the best way in the order in which to deal with those matters? Should we get the case management issues over quickly before we launch into the... There's not much in the case management issues, is there? There's a bit of disagreement about dates. And that's all. Do you have a preference, gentlemen?
I'm quite content for that, Your Honour.
All right.
I think Mr. Montague Smith is ready to deal with it.
All right, in your hands, whatever is most convenient.
Well, I think it'll be easier to get those matters over with while we're fresh. They won't take long, I don't think. So, Mr. Montague Smith, are you going to address me on it? Or Mr. Hubble, would you like to address me first on those?
Sir, Your Honour, absolutely. You will. The documents that I think you will find absolutely most helpful are the draft directions order,
yes,
which is at tab 65.1764.
Yes, I've got that.
769. I'm very grateful. And yes, what you should find immediately behind that order at 1770 is a multicolored spreadsheet.
Yes, yes, I've got that. Got that also. Thank you.
Serves to identify the issues between the parties, which are narrow.
Yes,
Your Honour, you'll have seen that the parties have worked constructively in relation to directions, and there is agreement in respect of a trial commencing on the 7th of October 2026 with a reading week, and then starting live in earnest on the 14th of October 2026, subject of course to Your Honour's views on listing. The issues that arise relate to the directions to get from here to that trial, commencing on the 7th of October 2026.
Well, could I just pause in relation to the trial? I mean, there's a couple of things about that. First of all, if we're going to fix those dates, then it has to be on the basis that everybody will adhere to this timetable. And so that, in other words, applications to extend times will be rigorously scrutinised. The other issue is that this will be the longest trial ever conducted in the DIFC, and I'm just not sure presently whether we have a judge available to hear it over that length of time in late October 2026. So any dates that are fixed today would have to be provisional on the basis that we can in fact find a judge who's able to hear it over that length of time. In that regard, should I assume that everybody has in mind that the trial will be conducted in Dubai in person? Is that the expectation?
On our part, yes, I think that must be right. We're obviously in the court's hands, but it's a lengthy trial. There'll be lots of evidence.
Yeah. Well, that's my working assumption, unless there's any different view. So we're going to have to find a judge who's willing to spend that amount of time in Dubai if he or she's not already there. So, which may not be all that easy. But anyway, we'll do our best, obviously, to see if we can accommodate that. So, right back to you, Mr. Hubble.
Well, I'm very grateful, Your Honour. So, understood that the listing for the 7th of October 2026 is provisional, in the sense that it's going to be dependent on the finding of judge, and again, provisionally, the expectation would be that the parties would all be in Dubai. The differences between the parties in relation to the timetable breaks down into a difference in relation to intervals at 4 points in the timetable, and that can be seen from the yellow highlighting
Yes.
that one sees in the table at 1770. The first of those, Your Honour, relates to timings for draft requests to produce, where you will see that the claimants propose a date of the 28th of November 2024 and the defendants propose a date of the 19th of December 2024. And if I can provide you with a little bit of background, Your Honour, into
Yes.
where we are in relation to document production. The claimants by the joint official liquidators hold an extensive document universe we've identified in our CMIS of potentially in excess of 11.5 million documents. And as such, the search and review process that's going to have to be undertaken on behalf of the claimants is potentially going to be very expensive and costly. And so we were concerned to try and ensure that that review and search process was undertaken in as efficient a way as possible. And with that aim in mind, we propose that draft requests to produce should be exchanged prior to standard production, which I acknowledge is not the usual course, but this is not the usual sort of case. And after lengthy correspondence, that's been agreed in principle, and it's reflected in paragraph 6 of the draft order at page 1765.
Yes.
So the only dispute that resolves for Your Honour to resolve is when such draft requests to produce should be exchanged. And the claimant's position is that the draft should be exchanged on the 28th of November, just 3 weeks after the conclusion of this CMC, whereas the defendant suggests 6 weeks through to 19th of December 2024. The defendant's position is, so they say, that they need 6 weeks because this will all require some careful thought. We say that the 3-week period which we propose is preferable, but for 3 reasons. First, if the draft requests produced are not exchanged until the 19th of December 2024, then there's a serious risk that the benefits of exchanging them will be lost. And that's because we're going to have to make a decision about how and when we undertake our review exercise for the purposes of standard production. And if we don't get the draft request produced until the 19th of December 2024, the danger is that we won't be able to take it into account as we frame our search and review for document production purposes, because we're going to have to start it before then if we're going to hit the target of the 27th of February 2025. Secondly, we agree, of course, that the draft request to produce should be as comprehensive as possible, but that shouldn't be a license for further delay. And second and thirdly, we have to remember that we have provided our draft request to produce. We provided that back on the 14th of October 2024. So the defendants have had a considerable period of time to commence work on their draft, and we find it hard to understand why they would require a further 6 weeks. But really, we're driven by the imperative that we want to make sure that this timetable works. If the timetable works, we need their draft request produced in good time that we can take into account as we frame our search. Can I mention one further point that Your Honour may be able to assist at this point in the timetable, and that is in relation to audit files. The defendants have not yet set out their position on whether they will provide their audit files alongside standard production. We are very much of the view that the audit files should be provided as part of standard production for 2 reasons. The first is that they're obviously going to be of central importance to the issues in dispute between the parties. This is, after all, a claim for auditor's negligence. And second, the audit files ought to be readily available to and producible by the defendants. That's because the ICEs require the audit files to be maintained and accessible first. And secondly, as Your Honour will know, there have been DFSA investigations. Indeed, there have been decision notices against KPMG LLP, the third defendant. So the audit files have obviously been marshalled for that purpose. The suggestion from the defendants is that this request has come somewhat out of the blue. That's not something that we would accept. There's been a process of constructive engagement in relation to draft request to produce, and we've provided them with our draft request to produce on the 14th of October, and that includes requests for the audit files. So the suggestion that this has come out of the blue and the defendants can't be expected to know their position in relation to it is somewhat surprising, because they've had our request for some 3 weeks in relation to that. And fundamentally, Your Honour, we're simply keen to get this action moving and get this action moving on towards trial. And it is obvious that the audit file is going to be highly relevant. It makes sense for them to produce on standard production. So that was all I wanted to say in relation to the timing of draft request to produce. I'm very happy, Your Honour, to pick up the other 3 areas, or you may wish to hear from Mr. Montague-Smith now.
Well, why don't we break it up into segments? Mr. Montague-Smith on the request to produce.
Thank you. Yes, so this isn't the request to produce, this is just the draft request to produce. So it's just the timing of that. And so it doesn't affect the timetable going forward at all. So my learned friend has some overarching points about how the timetable up to trial is broken up. But this doesn't have a knock-on effect on or any impact on anything that comes later in terms of the timeframes. I'll explain this, but ultimately we say the sensible approach here is that we should be given the time that we need to make this as comprehensive a document as possible, because that's the only way it's going to be of any use. That's the overarching submission. But Your Honour will know that the rules provide for standard production first, and then for requests to produce. So parties produce first what they intend to rely on, and then each party asks what are supposed to be narrow and specific categories of documents after that. And it's right that the rules themselves do encourage the parties to exchange draft requests in advance, but they don't envisage the court actually making an order for that. Now we've agreed to that, and I'll explain how that came about. But if I don't know if Your Honour has the rules themselves, but Rule 2815 is the one that encourages an order for standard production.
Yes.
Sorry, Rule 2815, I apologise, is the one which sets out the order for standard production. So that says the court will order a time for that. But 2811, which is the one which deals with what the parties ought to do in part to cooperate before that happens, it suggests that parties seek to exchange preliminary production requests in draft form, and then says any such exchange shall not limit the parties' rights to submit further requests to produce. So that is guidance. It comes from the Commercial Court Guide as it existed back in 2005 and was transplanted into the DIFC rules. And so the guidance is that they're just going to be drafts, and you shouldn't be bound by those drafts, and they can be added to. And we say there's a reason why the rules provide for an order for one thing, standard production, but not an order for the other thing. We say that's inevitable because it's only ever going to be a draft. It doesn't confine the way that you craft your requests further down the line. And the result of that is there's not an awful lot of point actually in ordering it at all, because there's no real sanction for non-compliance. Now, so initially, when the claimants asked for an order in those terms, we disagreed with that because we said it didn't add anything, essentially requiring us to engage in a process which is inherently voluntary. About a week ago, they said they wanted the draft requests to be met with a process of objections. So they wanted actually more detail. So effectively, they were moving towards asking us for 2 phases of document production with full requests and objections. Because they were saying, and this was the overarching point that was made, that otherwise they'd have to do 2 sets of searches, once for standard production, once for request to produce. But our point was, well, having 2 rounds of document production requests and objections is going to guarantee 2 sets of searches. But that complaint, which my learned friend repeats today, that there may be multiple searches, that is one that is often levelled at these rules, at these court rules. It is something that the court rules are intended to try to mitigate, and so the rules, but fundamentally these rules are built to try to reduce the burden of the document production phase. So you've got the full English disclosure model, if I can call it that, is very expensive and can lead to disproportionate results. And so the result is that this court has moved away from that model to the arbitration model, but it does bring with it the risk that you have multiple phases. So searching for the documents you want and then searching for the responses to requests. But the policy decision made in this court is that is better than the alternative. And so ultimately, my own friend's complaint really is about the rules, not about this particular directions order. And doing things like exchanging draft requests is definitely a sensible mechanism to try to capture more in the first round, and so limit the second round. But as I pointed out, it doesn't limit the subsequent requests. Now, ultimately, the claimants dropped their request for 2 rounds of objections, but to alleviate their concerns that about this aspect, we agreed to an order for draft requests, but we do need some time to prepare them. The claimants initially said we should have 2 weeks, and now they generously offers us 3 weeks. The bottom line is, to do a proper job on this, we need 6 weeks, by reference to the capacity of the legal team, and to the fact that it is a complicated and potentially quite difficult job. So the claimant's draft request starts on page 1631 of the bundle. I don't need you to go through it in any particular detail, but it's a 24-page document with, as one might expect, a dense and densely argued list of 17 categories of documents. Now, we have therefore asked for 6 weeks for this. In a sense, we're voluntarily agreeing to an order to what is ultimately a voluntary process. So that takes us to the 19th of December. They'll have our drafts then. They then have further 10 weeks until standard production. Now, they say that presents them with a challenge, but the short answer, as I say, is surely the better approach is to give us the time that we need to ensure that our drafts are as comprehensive and precise as they can be. Because the alternative is just that Your Honour forces us to rush out draft requests in a time that means that they're not as useful as they might be. So, I mean, what I say is the claimant's submissions appear to approach this on the basis that the parties will effectively be front-loading document production into this first standard production phase. And to an extent, of course, that's what we'll be trying to do, but it's always going to be subject to the parties' rights to expand requests later. There will inevitably be further requests that will be asked later. There will inevitably be a search phase later. And that's going to arise because either the requests are in the drafts and they're not accepted. The requests are in the draft and they are accepted, but the documents that are produced, there's a disagreement about whether they fully meet the request, or because requests emerge in time over the year or so between these draft requests and the next round. And that could happen because parties' thinking develops, or it could happen because something emerges from the documents that are produced. So there's inevitably going to be a second round. And so ultimately, the choice that Your Honour has is between giving them more time to deal with our draft requests at the outset, but risking that less of our total requests are caught, or giving us more time to formulate comprehensive requests, but still leaving them with 10 weeks to comply, and always knowing that if they can't, then it's not fatal, because they don't have an absolute obligation to do so, because they can simply leave over the ones they're not sure about until they're able to deal with them in the next phase, if there are any. So we would say, don't rush us into doing a bodged job of this. Ultimately, we think we can do a good job in 6 weeks, but we don't think we can do one in 3 weeks, and that really ought to be the answer to this.
Thank you, Mr. Montague-Smith. Mr. Hubble, in reply.
Your Honour, short points in reply. We accept the structure of the rules set out in the RDC, of course, but as we've adverted to already, this is not the usual scale of case. We have a vast amount of documents, and we are simply trying to be as efficient as possible in the way we deal with document production. And we are keen to minimise the risk of multiple phases of review and the cost that will incur.
Well, Mr. Montague-Smith says if you will exacerbate that risk if you force them to put on an inadequate draft request.
Understood, Your Honour. It's really a balancing exercise. We don't want an inadequate draft request from them, of course. We're surprised that they're going to need another 6 weeks in circumstances where this has been in discussion for a number of weeks, and they've had our draft since the 14th of October. And the balance is, we are very keen, of course, to have a meaningful draft request to produce, but to have it in sufficient time so that we can incorporate it into what will be a very sizable search that we're going to have to undertake. And the longer we have with a proper draft request to produce, the more effective that will be, and the less cost is likely to be incurred in round 2 of searching. So, Your Honour, I quite accept it's a balance. We don't want a rushed draft request to produce. We're surprised at the suggestion that it would be rushed in the particular circumstances here.
Yes, all right. And Mr. Montague-Smith, I forgot to ask you, what's your position in relation to the audit files?
I don't have any instructions today to agree to this. My learned friend says this doesn't come out of the blue, because it's one of his 17 requests to produce in a very lengthy document, which is just a draft, and which we haven't engaged with yet for the purposes of actually doing any searches. Of course we haven't, because we haven't reached that stage yet. What comes out of the blue is the request that this particular category of documents should be extracted from that draft request and put into an order for the purposes of today. It does come out of the blue. It came out of the blue on the 28th of October. The first time it was raised was in a letter from my learned friend solicitors on that day. You can find that, I'm told, at page 4376. I think it's a late addition to the bundle, but I don't necessarily need you to read it. It just comes in very late in the day. The short answer to this is there's no application before you for specific disclosure or early disclosure in relation to this category of documents, and I'm not in a position to accede to it. In fact, the claimants confirmed some time ago they wouldn't be making any applications at this case management conference. They said that in terms in their case management information sheet, and you can see that on page 1757 of the bundle, paragraph 18 of which says, are you going to make any applications? The answer comes back no. And then a week before the hearing, they request these further documents be incorporated into Your Honour's order. A standard production, as we know, is supposed to be the production of documents on which parties themselves rely, not some sort of expedited process of request, not even allow us a chance to consider that and decide whether to issue an injunction and then ask Your Honour to rule on it. The defendants have received that draft request. It includes the request for the audit files. It will, as we would say, we have said several times, we will take those requests into account in determining what disclosure to make, but I cannot make, on behalf of my client, a specific commitment now about whether that or any other draft request will be included in the standard production. And I would suggest it would not be fair to make an order against me on that today. In virtually every case, it is possible to say that there is some really important class of documents, but you have to make orders, we say, which are even-handed. Otherwise, it would have been open to me to make ad hoc requests for categories of documents a week before this hearing and expect you to deal with it. We don't accept that it's necessarily as straightforward as simply handing over a file. We don't have any evidence before the court as to what actually is or isn't included in that. My understanding of this is likely to be pretty limited. So I hesitate even to tell you on submission.
No, I don't want evidence from the bar table about what the documents are.
Of course you don't, but we don't have any evidence because there's no application. So I think that there may be arguments about what there needs to be. There may be a physical file. There may not be a physical file. I don't know. And I'm sure somebody in my team knows, but I don't. And there may also be arguments on an application of that sort about the court's powers and how the court should exercise those powers to order specific disclosure in a case where, in fact, there's a discrete regime in the rules for production requests, objections, and orders, and so forth. So I would suggest that this is not the right way to make what is effectively an ad hoc disclosure application without evidence, without proper submission. That's really where I think we're left with today.
Right, Mr. Hubble, in reply on this issue.
Well, Your Honour, we remain very surprised at the idea that there can be something unusual and unexpected about a request for the audit files in a very large-scale audit negligence case following on from detailed DFSA investigations. So it would seem a commonplace to us that the audit files are going to be provided, and we simply invited that guidance from the court. But beyond that, I don't take it any further.
Well, I'll give the rulings of these as we go along. In relation to the audit files, it's my view that there may be some ambiguity or uncertainty as to precisely what that expression comprehends and entails in what I assume would have been a large-scale audit. It may be that there are some of those processes that are only conducted digitally rather than in paper, and so there may be issues there. But the short point is that I don't think that a timetabling direction is the place or the time in which to make it what is in effect in order for specific disclosure in the absence of an application. So in the absence of consent, I don't think it would be proper for me to make such an order today. Whether or not those files are within the ambit of standard disclosure and should be provided is a matter that can be debated on another occasion, more appropriate. In relation to the issue with respect to the time for the exchange, for the provision of the defendant's draft request, as is conceded, this is really a balancing exercise because on the one hand, the utility of the document will be enhanced the earlier it is given and the earlier into the process of searching for documents to be produced on standard production the document is received, the better for it to achieve its purpose. But on the other hand, if that process is rushed, then the document will be inadequate and will not achieve its greatest effect and will result in second round of searches of wider ambit. Doing the best I can to strike the balance, I think the draft should be provided on the 12th of December. That is 1 week less than the period proposed by the defendant, but I think that week, being a week before the Christmas break, could be an important week for the claimants in order to feed that material into their search processes before the Christmas break. So what I propose to do then is direct that the draft request be served by the defendant on the 12th of, no later than the 12th of December. So where's the next difference, Mr. Hubble? I think it is the request to produce is the next one, isn't it?
It is,
yes,
Your Honour, and so that you understand the shape of the dispute, because I think it really applies to all the remaining 3 areas where there's an element of tension between the parties, is the parties are agreed that we need to get to a trial starting in earnest on the 14th of October 2026. The areas where there's controversy between the parties go to how quickly we get to the pre-trial preparation phase. And you'll see from the spreadsheet that the defendants have a longer series of intervals in relation to the three areas highlighted on the timetable, the end result of which is that the progress monitoring date on the 22nd of July and the PCR on the 29th of July 2026 would each take place before the closing of evidence on the 20th of August 2026. That's on the defendant's timetable. And that the claimants should then be required to file their skeleton argument on the 23rd of September 2026, which is only 5 weeks after the close of evidence. So our concern is on the defendant's time frame, we get very bunched up in terms of directions and trial preparation in the period immediately prior to the trial. So we have slightly shorter intervals in 3 periods at an earlier stage in the directions, but the first of which is the exchange of requests to produce, which is the second highlighted row, where we suggest 4 weeks should be sufficient to allow each party to finalise their request to produce following standard production. The defendants seek 6 weeks. Now, at one level, I don't want to take up a huge amount of your time, Your Honour, in relation to a debate about the difference between 4 weeks and 6 weeks, but the consequence comes with the knock-on effect on the danger of a bunching up of the timetable later on in the litigation process. It seems to us that 4 weeks ought to be sufficient. First, we will have had draft requests to produce. I accept that drafts are only drafts and they will be finalised and formalised later on. But we're actually talking about a process in which work on requests to produce will already have been done. And it ought to be capable for the parties to absorb material that's been produced and to not draft requests to produce from scratch, but to finalise draft requests to produce that are already in existence. And so with that aim in mind, Your Honour, we propose 4 weeks rather than 6.
Yes. All right, Mr. Montague-Smith. Do you want to deal with these 3 together, or is that convenient?
I'm very happy to deal with these 3 together. Your Honour, the next category is production following DPOs, document production orders, where we suggest that the long stop date for production of documents responsive to any document production order should be set at 12 weeks after the deadline, with an aim of 8 weeks within that. The defendants, for their part, suggest a long stop of 14 weeks, with an aim within that of 11 weeks. We appreciate, of course, that this depends to a certain extent on the court's ability to deal with court's ability to deal with any outstanding issues in relation to document production. The parties have done what they can in relation to that by building a presumption into the draft order that matters should be dealt with on paper. But the aim here is that we will have had draft requests produced, then we will have had standard production, then we will have had requests produce. And so it's a reasonable expectation, perhaps hope, let's say expectation, that the ambit of disputes may be relatively narrow. And so setting this at 12 weeks, again, just affords a little bit more slack in the timetable later on when we come to ensuring that evidence is closed in good time so the parties can take stock, have their PTR, and prepare for the trial, which is obviously going to be a heavy undertaking. The third category, third and final one, is under the heading experts, Your Honour, and this is the time period for the production following a sequential exchange of expert evidence. This is the time period for production of the defendant's expert report. The claimant suggested that should be 12 weeks after service of the claimant's expert evidence. The defendants seek 14 weeks. The defendants say that they're going to need 14 weeks because the position, particularly on quantum, is likely to be complex. I don't dispute that the position is likely to be complex. The issue again is coming up with a timetable that's going to be workable through to trial. So far as they're concerned about the complexity in relation to quantum, the parties have sought to address that by the fact that the claimants are going to provide further particulars of their case on quantum on the 2nd of January 2026. So actually, that further particularization is going to be received on our timetable 2 weeks in advance of delivery of our expert evidence. So there's actually going to be 14 weeks from the provision of those particulars in relation to quantum. So we suggest that 12 weeks really should be sufficient for the purposes of sequential exchange of expert reports. And the overall desirability of this is that we will bring evidence to a close a reasonable amount of time in advance of first the PTR and to enable the parties to then prepare for trial.
Yes. All right.
So,
Thank you.
Your Honour, those are my submissions on those 3 points.
Thank you, Mr. Montague-Smith.
Your Honour, yes. So we're dealing with the 3 gaps. One is, if you've got page 1770, that's the spreadsheet. It's probably the most useful.
Yes, I do have it.
So it's the first one is the gap between standard production and requests. So this is the gap in time between receiving the other side's documents and then sending them the final request to produce. And then we've got the time to respond to the request. That's the 3rd yellow line on the page. And then we've got expert reports. And I will explain my position in relation to each of those, but I'll just respond to my learner friend's overarching point first, if I may. I mean, and I start like this. Ultimately, we've got 2 years to prepare this case for trial. So there should be sufficient time in that timetable to ensure that everybody gets the time they need to complete those steps. So unless there's a reason to compress any of these, my starting point, Your Honour, would be that you shouldn't. And we have to bear in mind there are going to be a lot of documents in this case. My friend, I think, has said there's over 11 million documents, and we've got I think about half of that. But that process is going to be extensive. Some thought will need to be given to formulating requests, and the process of actually searching for those documents is going to be onerous. And just to give you a headline of what we say about the expert evidence, yes, it's going to be complicated, but that's not our only problem. In fact, the difficulty we face at the moment is we don't really know what the quantum case is. So we're going to be starting very cold once we get their expert evidence. So at the other end of the process, if I can put it like that, starting at the end, the central complaint that we're hearing is that the timetable has evidence closing 3 weeks after the PTR. That's the main complaint, and 5 weeks before the exchange of skeletons. But if you look down on page 1770 at the spreadsheet under the heading experts, you will see that the only thing that is going to be, I mean, what my learned friend's referring to is the final step in the experts process, so the service of supplemental expert reports. So that you'll see the CMC date underneath, subject to the court's approval, but we've got we propose a CMC date of 29th of July, and on our timetable, by that time we will have they will have served particulars and then expert reports, and then the experts will have met, and the experts will have produced their joint memorandum. If you see that, that's the second last stage. And so all that is left at that stage is the supplemental reports. And so firstly, just looking at the question of whether it matters that comes after the PTR, it seems to us that the prospect that anything in those reports is actually going to affect issues arising at the PTR itself is vanishingly small. And if Your Honour's experience is the same as mine, in my experience, it's extremely rare that anybody would actually point to anything in a responsive report like that because it won't go to any of the issues. So the real complaint, it seems to us, is that this is about trial preparation. It's not going to make any difference to the bundle. I suspect we may not be using the court's bundling system. We may have to use something like Opus or something like that, but we haven't discussed that. But either way, if it's Opus, it'll just be capable of slotting this evidence in. Even on our timetable, we'll have the supplemental reports before the bundle is finalised, so it won't affect the nuts and bolts of that sort of thing. Now, of course, there's going to be a lot of preparation required for trial, but on this, the supplementary expert reports will be available nearly 2 calendar months before the first day of the hearing. It's about 8 weeks, so it looks a bit less because we put in a week of reading into the timetable, but it's about 8 weeks between supplemental reports and day 1 of trial. And of course, we're talking about expert reports. So when are we actually going to get to the experts in the trial? It's unlikely to be until the second half of the trial. My own friend's complaint is in part about the timing of supplemental reports relative to the exchange of skeleton arguments. But as I say, the joint statement will set out the experts' positions in outline in July. That's nearly 3 months before the first day of the hearing. And again, it seems unlikely that the parties will need to address in skeletons the detailed criticisms of the supplementary expert reports from the other side in their opening skeletons. There might be some broad observations, but the detail of all of that is going to be really for cross-examination and closing. So we do say that in the overarching point is a little bit overstated, because yes, it's right that the supplemental reports are coming after the PTR, but that doesn't actually affect the PTR, and it seems to us that there's plenty of time to prepare for trial in an orderly way. Now, against that, and that's really the point that my learned friend raises as to why we shouldn't have this extra time built into the timetable. Against that, we need to assess the areas where the claimants want to actually put a bit of pressure on the timetable. And the first of those then is this gap between standard disclosure and request to produce, and this 4 weeks that they suggest versus 6 weeks that we suggest. Now, the central reason why we think it's sensible, bearing in mind Your Honour's point that if we're fixing a trial date, everyone's going to have to stick to it. The reason why we think this is sensible is because we will, it looks like, be receiving a large volume of documentation from the claimants. And my learned friend describes the first round of production as a gargantuan exercise. That's the way he puts it in his skeleton argument. So we may very well be on the receiving end of a lot of documentation, and we will need time to review that before we can finalise our requests, because those final requests are going to be informed substantially by what is produced by the other side. We will have, first of all, we will have served our draft requests, and no doubt the documents produced will be said to answer some of those requests. We will need to go through that carefully to see whether or not we agree with that. But secondly, we may by then just have other requests that we want to raise. Now, that will develop that, but we will need to check whether those documents which have already been produced cover the requests that we would otherwise want to make, or whether further requests will need to be refined a bit, because they have to be specific, and we need to tell the court that we haven't got those documents. But third, and in my submission, the most time-consuming bit of this, we will need to assess whether the documents which are produced trigger further requests. This is particularly true in a case where, like this one, there is fraud at play, but by the people who are running the Abraaj entities. So there's a whole cluster of issues in this claim, which is focused on the conduct of the claimant companies and their senior management at the time, and what people knew, what they did, but also prospectively what they would have done if they had been challenged at the appropriate time, when the claimants say they ought to have been challenged on the various irregularities that arose. And part of the case is that wouldn't have taken anyone anywhere, because it just would have led to further obfuscation. So the claimants are likely to have a large volume of documentation which is relevant to that, and it's going to be necessary to take a pretty forensic approach to investigating the documents which are produced and see what more there might be out there. And Your Honour will know that that can be an extremely detailed task. Sometimes there's just one document which can trigger a line of inquiry. And that investigation will need to be followed by careful crafting of requests, which will need to be narrative focused to be sensible and acceptable to the court. So if we assume a couple of weeks for that drafting process, which is not unreasonable, I would suggest, that leaves only 2 weeks for the document review process. And given the volume, we suggest that's unlikely to be a realistic task. That's why we're asking, in effect, for 4 weeks and 2 weeks. Which gets us to 6 weeks. And the only objection to this is the overarching one about timing leading to responsive expert reports and so on. And we would say, in striking the balance, if you accept my own friend's submission that puts people under some sort of pressure, that's where the pressure should come, not by effectively halving the investigationary period when we will be looking at their documents. As to producing documents, then that's the second one. The difference is, as my learned friend says, between 12 weeks and 14 weeks. So this is going to arise where there have been objections, that those objections are disputed. So you've got the request for production, some of them are objected to, there's a dispute as to that objection, and then there's an application to the court, and then the court orders some production. So ultimately, that entire process will need to be kept under review because it depends on how quickly the court can issue a decision on this. And the parties have therefore, in their discussions, provided for 2 periods. The first is a sort of estimate about how long there should be when responding to an order, and the second is the backstop that you see in the timetable. And in a sense, it's really the backstop that matters the most, because the timetable is built around that. So if Your Honour has that timetable and then goes to the order itself as well, I don't know whether you're able to open them both at the same time, but if you can, maybe helpful.
I've got them in hard copy.
Oh, that's very helpful. It's paragraph 13.
Yes.
So you've got essentially the time for compliance is within, and then 8 or 11 weeks, and in the event by, and then there's the 2 dates. Actually, I think we may be slightly at cross purposes here, because my own friend's assuming 4 weeks for the courts for the application process, if I can put it like that, whereas we're assuming, it looks to me, 3 weeks, but I'm not sure that is realistic. But in any event, the difference between us is 2 weeks, not the 3 weeks that appears from that. It may be so. There are a couple of points. One is we need to bear in mind that the court just might not get there in the time that we're all providing for. But the other is that it comes back to this overarching point that there's a slight disagreement, I think, about how the parties anticipate that these sorts of orders usually work in practice and where the burden really comes on these sorts of disclosure exercises, because the claimants are under the impression that the burden comes at the start, but we're not sure that that's quite right. And actually the burden of actually doing the searches and finding the documents is going to be substantial, it seems to us, at the second stage. And if I could just direct your Honour to my learned friend's skeleton argument, you'll see, I mean, he does to some extent accept that there is a risk here, because if you go to page 4, and if you see footnote 9,
yes, got that.
If I can just invite Your Honour to read that.
Yes, thank you. I've read that.
So my learned friend accepts that if the burden of the work or the majority of the work comes at the second stage, the request stage, it's going to be challenging to meet the broader timetable. And our experience is that the greater burden comes at the request stage. With the greatest will in the world, we are never going to achieve the result that the parties are only really searching once. So, as I say, first, the requests are going to inevitably develop. Second, they will develop both because the parties' thinking develops, but also because documents will trigger fresh requests. And third, because the parties may not agree that every request that is made. So they may just not produce the stuff at the first round and then be ordered to do it at the second. And then parties may not agree that production has been complete. So there is likely to be a search phase. The claimants accept that if that's a heavy phase, 8 weeks may not be enough. And our experience is that is likely to be a heavy phase. Now, as for the backstop, as I say, I think we've used the date we've used assumes a 3-week resolution on our side and 4 weeks on theirs. So if we do a like-for-like basis, it's really a difference between 8 and 10 weeks to respond to these searches. But just bearing in mind that 4 weeks means, firstly, you have the application. There's 4 weeks from the application. 4 weeks means 2 weeks for responsive evidence, 1 week for reply evidence, and then the court issuing a decision within 1 week, which is ambitious. So, of course, real and substantial issues may arise on that application. There may even be a need for a hearing. We hope not, but there may be. And we'll have to keep that under review anyway. But we say it's not sensible to build in a very tight time frame for this, bearing in mind Your Honour's comments in relation to that. As to experts, we are asking for 14 weeks from the date that they serve their reports. They're happy to agree to 12. And as I mentioned, the difficulty for us is not just the complexity of the quantum exercise. My learned friend says, I accept it's going to be complex. We don't know, because the pleading on quantum is extremely thin at this point. Can I ask Your Honour very briefly just to look at page 166 of the bundle, just to show you what is pleaded.
Yes, I've got it. Thank you.
Thank you. I think this is right. So there are two. No, that's not right. I'm afraid my pagination has gone out. It may be me. Probably is me. It usually is me. I'm looking for paragraph 68 of this document. So
I'll scroll down to that. Yes, I've got 68.
Bear with me. So I do apologise.
That's contractual exclusions and limitations.
Yeah, that's not the right page either. I'm so sorry. There we go. It is page 64. I have no idea why I had page 166 there. That's my fault.
All right, I've got page 64. Thank you.
Thank you. So that the way it works is that two counterfactuals are pleaded. So that there are all these allegations of breaches of duties in the conducting the audit, and there are two counterfactuals pleaded. Essentially, paragraph 68 pleads out what is referred to as the primary case, which is that the companies would have traded out under new management if this had been raised. And paragraph 69 is the alternative case, which is they claim the additional liquidation shortfall which arose because the company wasn't placed into liquidation sooner. And then you've got paragraph 70, and you can see the provisional estimates of loss are pleaded out 70.1 on the claimant's primary case, at least $600 million, and potentially substantially higher in circumstances where the potential shortfall on their liquidation alone is currently estimated to be up to 1.8 billion. So that's the primary case. Secondary case, there is a bit more detail. Again, at least $600 million, including, firstly, some said to have been extracted by Mr. Nakvi, 136.4 million in trading losses between the earliest date that they say this should have been discovered and the liquidation. And by the way, there are lots of alternative dates put forward. The case is this should have been discovered by X date, then Y date. You can see all of those dates in the pleadings. But then they go on. So there's trading losses said to have been incurred. Say then there's liability for the fines, which you're going to go on to deal with. Then there's the dividends at 4, investigation costs, lower realizations from less orderly liquidation process, where the loss amount is unspecified, and other claims which appear more speculative, or alternatively a loss of a chance. Now, you've heard, or you will have seen, that the claimants propose experts in auditing, and that goes to the breaches largely. Also in forensic accountancy and restructuring. Originally, they asked for an expert in private equity markets and restructuring, and now it's been amended just to restructuring. We said we didn't really follow what that was about because we don't really know what the case is, but we agreed largely on a pragmatic basis because this is a substantial claim and the court is likely to say the claimant should have the opportunity to put the case the way they want to put it within reason. But we still don't really know the detail, and so our experts are going to be coming to this very, very cold. So the explanation that we have in my learned friend's skeleton argument, we look at that very briefly at paragraph 26, and it's 26C for the restructuring expert. First, C1, it goes to solvency. What other sources of external funding would have been available? And if we think about what our expert is going to have to do here, they're not going to see that until early 2026. And then they're going to have to consider a series of allegations about funding, which it said would have been available at a series of dates, which start in more than a decade beforehand. And the first of those dates is September 2013, and the alternatives run into 2017. And they're going to come to this very, very cold, because the first time we're going to see that is when we get their expert reports. The second point is what an orderly insolvency process would have involved and the differences between this one and the orderly process that should have been undertaken. We're not told what were the problems with this insolvency process, nor what their impact would be. So again, they're going to be very cold to this, and the forensic accountant will also, no doubt, be presented with highly complex models which they need to analyze and respond to. Now, our experience of this is that it very often takes something in the order of 3 calendar months for experts to turn those sorts of things around. We've suggested 14 weeks, which just gives us a tiny little bit more time because of how cold our experts will be coming to it. Now, as my learned friend said, in part we sought to mitigate this by asking them to provide particulars of quantum, but it's hard to know what that is going to look like. And if you go back to the timetable, you can see that on their approach, that pleading comes on the 2nd of January, which on their approach is only a couple of weeks before they serve expert reports. It's a bit longer before on our timetable, but two more weeks in the context of 2-year run up to trial is going to be it'll help, but it won't solve the problem. So the bottom line is, given the time that there is to get to trial, it should, we say, be possible to program this without putting my clients under pressure on this. And our concern is that they will be under pressure as a result of this because of the way in which the claim is being presented. And really, the only response to this really is this overarching point. So again, it's a balancing exercise, and the court has a choice on all of these points. You got the 4 weeks, 6 weeks on document requests, 8 or 10 on production, and 12 or 14 on experts. The first 2 affect both parties equally. The third one only affects us. But the court's balancing exercise is you can either put the parties under pressure, which is what we say will be the result, and we say that risks unfairness, and it also risks this coming unstuck and parties having to come back to the court and asking for extensions. we can program it the way that we suggest. And as I've explained, we cannot see that realistically that is going to make any real difference and put anyone under pressure for the trial preparation. I mean, the only other solution would be to push the trial back by 6 weeks, but that's not something that we propose that you do, because we don't think you need to do it, because we think we can reach a trial in an orderly way.
Well, I just wonder about that, Mr. Montefiore, because the times are tight, and there are some unknowns in there. For example, and it seems to be the biggest probable risk at the moment is the time for contested production requests. And the problem is, if you design a timetable that in a perfect world arrives at a trial date on time, that's fine. But we all know the world isn't perfect. So I can understand with eminent senior counsel on both sides, it's important to get those dates locked away. The problem is, if we lock them away and then fall short and have to adjourn the case, then it's going to be harder to find places in people's diaries again. So I just wonder if it wouldn't be more pragmatic to build in a bit of fat on the basis that there is some allowance for slippage, a bit of float, as the construction lawyers would say, on the basis that we can then be confident that the trial will go ahead, and counsel can reserve the dates on that basis. I just wonder if that's been thought through, really. But I'm not
aware. Well, look,
we're be ready on this for start on the 14th of October or whenever it is. Then I'm not going to stand in the way. But I just wonder if it's a perilous exercise. That's all.
Well, we're very much in the court's hands. We think that with our timetable, it should be achievable. Obviously, the critical thing is that we do. I mean, I think there's no avoiding that we have to lock it down, because it's, you know, a significant commitment in people's diaries, and ultimately, actually, what's driving the timetable, the trial to some extent, the trial fixing to some extent, is that's the earliest that we can find in everyone's diaries to do it. Realistically, but we're very much in Your Honour's hands. We don't think that the timetable should be compressed in the ways that my learned friend says it should be. Subject to that, we think we can get it done. But if Your Honour, we're in your hands. If Your Honour has the,
I just say if these ambitions aren't fulfilled, then the maybe end up quite a lot slower in the long run. But if that's a risk everybody's going to take, then there it is. Anything else, Mr. Montague-Smith, on these dates?
Nothing further from me, unless you have any questions.
No, thank you. Mr. Hubble.
Your Honour, two short points. The first is we are keen, if we possibly can, to maintain the date of the 14th of October for trial. Your Honour, I think, was himself heavily involved in the jurisdiction battles. The claim for was issued back in March 2021 in this case, so we're keen that this case should be moved on to trial. Secondly, this is another area where really we're looking for balance, Your Honour. It's if our concern is if you look at the spreadsheet, and if you look at the last two entries under experts, the defendants proposed the 23rd of July for the joint memo. We proposed the 11th of June. They proposed supplemental reports on the 20th of August. We proposed the 9th of July 2026. Now, the dates that then run up to trial from progress monitoring date onwards are all agreed. That's why they're shaded green. So there's no dispute between the parties in relation to those. But if we're having the conclusion of the expert process as late as the 20th of August 2026, then we just have got a very tight timetable through to the 23rd of September 2026, when we are serving our skeleton argument. So it's not really as granular as saying, oh, well, you'll only get the supplemental report and not too much is going to turn on that. Supplemental reports from experts are actually very important because they serve to narrow the issues. But that's the end of the process in relation to evidence. And there's just a tight time period between that and the service of skeleton arguments. So we invite the court to do a small amount of trimming, acknowledging that it's a balancing exercise between pressure on the parties in a run-up to trial and ensuring those directions can be hit, but also having an immediate pre-action, pre-trial process that's realistic.
Yes. All right. Thank you. Well, I'll give the reasons for the view to which I've come, and that is that they can be expressed very shortly. Both parties are anxious that this trial commence its actual hearing on the 14th of October 2026, on the basis that there will be a week of reading preceding that hearing. Parties have disagreed as to the precise timetable that will best achieve that outcome, but both are committed to that outcome. And so the task of the court really is to strike the balance between, if you like, an ideal world in which every party would have ample time to do whatever step they think, is required, on the one hand, and on the other hand, moulding the times so that their joint objective of commencing the hearing on the 14th of October can be achieved. It's an exercise necessarily undertaken with a degree of speculation at this very early stage of the proceedings, because we don't know what issues are likely to emerge, and we don't know how much time is likely to be taken by each of these steps. So it's all a bit of crystal ball gazing to some extent. I am concerned that the timetable proposed by the defendants would leave a number of significant steps a little too close to the hearing for comfort, including the provision of the joint memo and the supplemental reports in a context in which the skeletons have to be produced shortly thereafter. So I think there is advantage in doing a little trimming, and so the argument is how best to achieve that. I've listened carefully to everything everybody said about the various steps. I don't think there's any particular science in this, so at the risk of being Solomon-esque, I think the best way of achieving a little trimming is to, in relation to the first disputed gap, which is the time for the service of requests to produce, I think that period should be 5 weeks from production. In relation to the estimated production of documents in response to the disputed requests, again, this is not entirely within anybody's control, but I think the aspirational target here should be 13 weeks. And in relation to the defendant's service of the expert reports, I understand the problems that Mr. Montague-Smith anticipates, but they may not emerge, and let's hope they don't. So I think that time should be 13 weeks. Now that will effectively, that's splitting the baby down the middle, as you've seen. So that gains 3 weeks. I think it would be desirable to put the PTR back until, say, 7 days after the last step in the process, which is I believe will be the service of the expert reports, which, if my estimate is correct, will now take place around the end of July. So the PTR could take place in early August, although I understand that that could be problematic for counsel and judges based in the Northern Hemisphere. But would the end of July be better than early August in that regard, or?
You're on a yes.
Yes. All right. Well, I think, okay, well, we should leave the PTR then, but there will be some trimming there, so there will be a lot more done by the PTR. The other thing that I have in mind is that I think it would be useful to identify the lucky judge who's going to get to hear this case, and then I think that judge should basically run the case from now until trial, and that judge may, of course, leave it to him or her to decide how often they want to see the parties, but I think there should be more frequent checking in than just a PTR. So I expect that the judge should be listing case management hearings at a fairly regular basis, not so often as to be burdensome, but at least often enough to keep an eye on progress. Although the judge will probably be seeing the parties regularly if disputes arise in relation to various interlocutory steps and pleadings and so forth. So what I think then, what I'd like the parties to do if they can, is to try and rework the very helpful minute which they've prepared on the basis of those directions. So So, and I think all that'll be changed is that, as I say, the period will go, period for service of requests will go to 5 weeks from the production of documents. The estimate of production for production of documents will come down a week, and the defendant should produce its expert reports within 13 weeks of service of the claimant's reports. And we can leave the PTR where it is towards the end of July on the basis that August is going to be a slow month. So, and again, if you could produce, hopefully agree a minute. If you can't agree a minute, give me competing minutes and I'll resolve it on that basis. Is there anything else in relation to the case management conference?
Your Honour, there's one thing that I should just update you on, which we deal with in paragraph, well, there are two short matters. One is the consequences of a restructuring of the KPMG group in the Middle East, where I don't think I'm not inviting you to make any orders in relation to that. The parties are in correspondence about it. They'll continue to correspond. I'm not in a position to seek an order from you in relation to that today. The other matter is the status of the second defendant.
Yes.
We deal with that in paragraph 29 of our skeleton argument. There is a considerable backstory in relation to this, Your Honour, but I propose to only give you the bare bones.
Yes.
There was an issue about the second defendant and whether it ever existed, and if it ever existed, in what form. It's described as KPMG affirm in the pleading in the particular claim, but it seems that in fact it was a sole establishment that was converted on the 29th of November 2012 into KPMG Lower Gulf Limited, which is the first defendant. And in the course of correspondence, the first defendant by their solicitors have confirmed that they won't seek to argue that the first defendant isn't liable, essentially because it was the second defendant. So that information has been given in correspondence. And in reliance on those confirmations, our intention is to prepare a consent order providing for discontinuance of the claims against the second defendant. So that's something that will happen following this case management conference. So that loose end looks as if it's going to be tidied up, Your Honour.
Yes. All right. Thank you. That's very helpful. All right. Well, if that completes the CMC, we might then move on to the other issue, which is the application to strike out and for immediate judgment in relation to the fines. Mr. Fenwick, would you like to address on that issue?
Yes. Good morning, Your Honour. As you will have gathered from the skeletons, this is an application for strikeout or immediate judgment of one specific but very significant in terms of amount part of the claim, and that is the recovery of the fines imposed on the two claimants. And we can just see where we actually plead that it's in A at 182 within the body of our defence, paragraph 64.2.5. And if Your Honour has it, we simply say that the fines are not recoverable as a matter of public policy, defence of illegality, and or as a matter of causation. Yes. And we make the point that the misconduct included deliberately misleading the defendants. Now, we'll have to spend a little bit of time looking at Grey and Thames trains in particular. But I do want from the outset to make clear that we're dealing here with the narrow rule in Grey. That is to say, we are simply dealing with whether the fines themselves are irrecoverable. And there seems to be, well, learned friend try, I think, a number of means of persuading you this is all too difficult and you should leave it over for trial. But much of their argument is based on questions of attribution, doubt, fact, which all go to the wider principles of illegality, which are not within the narrow rule, and are essentially as to whether, as between a claimant and a tortfeasor, whether an employee or agent or an advisor such as a KPMG, the illegality and fraud of those within the claimant entities bars the claim. And that's not what we're dealing with here. You will have seen from glancing at the particulars of claim that the claimants claim all sorts of losses, absolutely typical of an audit negligence case, against the defendants for their alleged negligent breach. And they do that despite averring the dishonesty and fraud of a large number of senior members of management. Now, all those matters will need to be dealt with at trial, but I'm not trying to strike those out.
Yes, but just pausing there, Mr. Fenwick, in terms of the impact of this issue on trial, it's not going to be significant, is it, in terms of leaving it over? There won't be, these are essentially issues of law. There won't be that many factual issues that would have to be canvassed, would there, at trial?
It is essentially a matter of law as a result. And what we're dealing with here is between half and a third of the claim. The $300 million of fines.
Well, I understand the dollars, and I misspoke earlier. What I should have said was additional factual issues over and above those that have to be resolved anyway. So no doubt Mr. Hubble will tell me in due course that there are issues of fact upon which these issues depend. So I'm not contesting that. What I'm saying is that, what I'm suggesting is that those same issues of fact apply to so many other of the claims that you're not applying to strikeout. So this won't, I mean, nobody's suggested to me that if the outcome of this application will make a difference in trial length between, it'll knock a couple of weeks off the trial or even more. And we've just fixed the timetable for trial, irrespective of whether these issues are in it or not. And there is authority, I think, for the proposition that in a circumstance such as this, the court should be loath to entertain a lengthy debate about issues of this kind if they're not going to have a material impact on the time taken at trial. I just throw that up for your comment.
Well, I understand. And of course, that's precisely what Mr. Hubble's trying to persuade you. He's trying to persuade you that it's so complex and fact sensitive that it will have to be dealt with at the same time as those same issues are being decided in relation to his wider claim. But my point is that this is in fact a very narrow issue of law. It won't add very much apart from the time of argument, which will be the same as the time of argument we're having now, to the trial length. But it is a claim which is barred by law and which on the authorities, when it's clear that the claim cannot succeed, the court should strike it out now rather than allow it to continue and distort the focus and size of the claim. I mean, if the learned friend were right and all this depended on a close examination of the facts, I wouldn't be making this application. It doesn't. It depends on an examination of where the law stands and where it doesn't stand. And so we say that because it's a straightforward, well-established question of law, the court should grapple with it now. If you conclude, having heard the argument, that it's all as complicated and fact-specific as learned friend Mr. Hubble suggests, then you will say it should go over for trial, and I accept that. But it's not. And that's why I wanted to make that distinction at the beginning. And when we actually look at the authorities on which he relies, they don't actually deal with the principle in Gray and Thames Trains, which is well established and has not been overruled and cannot properly be distinguished. And of course, I accept. And there are lots and lots. I mean, there's a ton of authority in learned friend submissions, all taking Patel and Mirza and what was said by Lord Toulson about the three-stage test and saying that you've got to have a look at attribution. In my submission, you don't. Can we just look, please, at the way the case is pleaded? Because I want to take this shortly. And if we go first of all to A/85.
Can you tell me what the page number is in the bundle?
Yes, 85.
85, thank you.
And this is a section where the claimants themselves set out the dishonesty and improper financial conduct and irregularities which took place within these two organizations and which in turn led to the fines which were imposed on them. And they go on for a number of pages. If we then go on to 96.
Yes.
We see the investigation, decision, and the fines which were imposed. Carry on regulated activities that have been authorized, misleading and deceptive conduct, and then the DFSA findings, including lack of authorization, actively and deliberately misleading investors, using artificial transactions, window dressing, and so on. And one sees that these are penalties imposed for deliberate and misleading conduct of the companies themselves. If we then go to 117, 70.23, they claim as part of their claim liability for fines that would not have been incurred but for the defendant's breaches of duty, provisionally estimated at 242 million. And then they're going to apparently bring in factual and expert evidence in order to see how much of those fines are said to have been caused by the defendant's breach of duty. Now, we say that I just want to pick up one more point, which is 318 in the reply. Paragraph 92. 318, paragraph 92.
Do you have a page 318, is it?
318.
Yes, thank you.
So the mere denial, and they're saying they're trying to recover the delta. But what is clear from all of that is that what they are trying to recover is all or part of the fines. This is completely different from their claims for losses which would have been avoided by continuing trade, loss of the opportunity to rescue the company, which they're two primary ways of putting their loss, which they say wouldn't have occurred had KPMG not been in breach of duty. It's necessary to look briefly at the actual decisions themselves. If we get a page 567, we have the AIML decision notice.
Yes.
And it's worth noting that there was no reference to the Financial Markets Tribunal, but right at the top of the page, the right to do so was flagged. Action, fine for the reasons set out. Identify over the page at 568, 115.4 million for unauthorized activity, 183.9 misleading and deceptive conduct, and 3 addressed to AIML alone. Nothing in this notice constitutes to determinate any person other than AML breach any legal or regulatory rule. Now, that's important because, of course, and Mr. Hubble makes a big thing of it, fines were also imposed on KPMG and on a number of the officers of the company. But these fines imposed on the company were imposed on the company for its own wrongdoing, not for vicarious liability for anybody else's misconduct. So when you have the authorities fining the entity for its misconduct, certain individuals for their misconduct, the two have to be looked at separately. And I won't take time up now looking at all of the details, but it's quite clear if we look, for example, at 571, where it said at paragraph 23, AML actively and deliberately misled the limited partners through their reports, financial statements, committee meetings, and correspondence. They actively misled and deceived them into believing their cash remained within the funds by taking a number of steps which are put out over the pages. At page 574, paragraph 36, said they shared common senior management. And then if we go to 578, paragraph 57, senior management were involved in the following: decisions on drawdowns, directing LPs, signatories, decisions, authorizing transfer. And then if we go to page 587, headed misleading and deceptive conduct by AIML, and 106, transferred Abraaj funds to operating accounts. AML used the fund monies for its own operating purposes. Other Abraaj funds concealed the fact it was doing so by providing misleading financial information to investors, making untrue statements. And then if we go to 608, we have the cross-heading misleading and deceptive conduct and the prohibitions on that. At 609, paragraph 239, the objectives, and this is important because the objectives for the imposition on the entity of these fines: preventing, detecting, restraining conduct that causes or may cause damage to the reputation of the IFC, nature, seriousness, and impact on investors, importance of ensuring people are not misled, and deterrent effect. And the DFSS considered.
Mr. Kenwick, is that 608 or is that 609?
609, paragraph 239.
Thank you. Yes, thank you.
And you'll see those objectives, very important here, because the objective here as a matter of public policy is to impose a fine on the entity because of the importance of preventing and restraining conduct causing damage, seriousness of investors, misleading investors, and deterrent effect. So that's rather different than something which can then be passed on to the auditors because the auditors didn't spot it. Consider the sanctions, fine is appropriate. over the page at 610, we see that what...
Just before we go there, the objective, as it said, and this is probably a matter of construction of the statutory provision rather than the enunciation by the DFSA, but the objective is to protect investors and presumably shareholders as well from this sort of conduct. And the same objective is why companies have auditors. Now, in this, and just bear with me, and of course, these companies are in liquidation, and on any view, there's going to be a shortfall, so that the investors and shareholders will get nothing, and the investors will not recoup all of their investments. So, in circumstances such as this, the objective of protecting investors is diminished if the fines are irrecoverable, because it will be, the investors will be doubly punished in that sense. And in terms of deterrence, deterrence is not a significant issue here, because the companies are in liquidation. The people whose action, you can't deter a company, you can only deter individuals from doing things. And so all companies have to act through individuals. So you've got to encourage people not to do these things. Now, these people have gone, they've been caught, some of them have been charged. I just can't see how the conclusion that these fines can't be recovered enhances the public policy objective of these provisions.
There is a distinction between the imposition of fine, and we'll see this when we get to the authorities, which is that public policy does not allow this kind of criminal or quasi-criminal regulatory fine to be recovered, because it would effectively contradict the policy of punishing the entity. Now, I accept, of course, that in an insolvent company, the losses will be suffered by the creditors and the investors. And that's why, when it comes to looking at whether in a company which is tainted by fraud, you have to look very carefully at the rules of attribution before deciding that you cannot recover from the auditor the losses which the company has suffered. Losses in the sense of trading losses and failure to avoid expenditure, which is part of the company's action. This is something different. This is the objective of restraining conduct by any company. If a company knows, and the shareholders know, and the directors know, that even if they act against these rules, even if they are fined, those fines can be recovered from the auditors, then that will weaken the impact and deterrent effect of those fines. And it's important to, when you look at 610, paragraph 244, that the DFSA considers the contravention to be particularly serious because it demonstrates a fundamental business model which is its core, involve the provision of unauthorized activities in or from the DIFC. Now, that's not something for which the auditors were responsible. It may be said that the auditors failed to cut it short, but the punishment here is being imposed for what the company did. And
this policy would also support rendering the auditors liable, because the auditors were, if you like, the first line of defence against some of these misconducts.
Well, the first line of defence is the company and its directors. And if there are no innocent directors, then there are all sorts of problems of attribution. It's the job of the company and its directors to prepare the accounts. The auditors have a role in auditing those accounts and providing assurance, and they can be held liable and held liable for them. Look, please, at page 613, and we see that there's comments here at 250B about the senior management directly involved in the conduct giving rise to contraventions, failing to take remedial action to stop the contraventions. And then 251, taking into account the replacement of the management, taking into account the provisional liquidation, taken into account the proactive state, but it's been taken into account in deciding to take the action. And they also take that into account at page 614 in the level of the fines imposed. You see that at 259 to 261. On the next page at 264, the right to make representations in person in writing, that wasn't taken up. Was given the opportunity to make representations, didn't take them up. Right to refer it to review at 270, not taken up. It's important to look at 267. If all or any part of the fine remains outstanding on the date which you pay, the DFSA may recover the outstanding amount as the debt owed and due to the DFSA. But before taking action, the DFSA will consider AIM's circumstances at the time and the corresponding implications of enforcing the fine for AML's creditors. So that's a decision within the remit of the regulatory authority. So there is an entire regime here for deciding that for which the company should be held responsible for its own wrongdoing, notwithstanding the existence of auditors, notwithstanding the replacement of management, notwithstanding the fact that at the end of the day, it is the creditors and shareholders who will suffer as a result of the fine. And all that's taken into account in deciding it. So that's the factual side of it. I'm not going to take you to the ACLD decision, which is on page 632, because it gives rise to similar considerations. There was a settlement with a 30% discount, but the principles of deception by the company are still present. Now, Your Honour, I understand and I hear what you say. Why, in that case, should the auditors not be on the hook for that as well in order to diminish the loss suffered by the creditors? The answer is it is a rule of public policy. And it's a rule of public policy which has been applied clearly and firmly. It's long-standing, it's still valid, and it's not a rule which is contradicted by any of the authorities my learned friend has tried to persuade you of. And we can go right back, I think, to the beginning. And if we go to page 1987, right place. This is the case of Holman and Johnson. Yes. Just and if we go back to 1986, let's see what this was about. Middle of the page, the assumption for goods sold and delivered. Lord Mansfield reported the case. The plaintiff was resident in and an inhabitant of Dunkirk, together with his partner, a native of that place, sold and delivered a quantity of tea, the price of which the action was brought to the order of the defendant, knowing it was intended to be smuggled by him into England. They had, however, no concern in the smuggling scheme itself, merely sold the tea to him as they would have done to any other person in his common and ordinary course of trade. Mr. Mansfield insisted that the contract was founded upon an intention to make an illicit use of it, which was with the privity and knowledge of the plaintiff, so he was not entitled to the laws of the country to recover the value of it. We then go over the page to 1987, where we see the objection that a contract is immoral or illegal as between plaintiff and defendant sounds at all times very ill in the mouth of the defendant. And that's Your Honour saying to me, why shouldn't the auditors, if they were negligent, be held liable? Well, the policy makes clear it's not for his sake, however, the objection is ever allowed. It's found in general principles of policy, which the defendant has the advantage of, contrary to the real justice, as between him and the plaintiff by accident, if I may say so. Principle of public policy is this: ex dolo malo non oritur actio. No court will lend its aid to a man who found his cause of action upon an immoral or an illegal act, if from the plaintiff's own stating or otherwise, the cause of action appears to arise ex turpi causa, the transgression of a positive law of this country. There the court says he has no right to be assisted. It's upon that ground the court goes, not for the sake of the defendant, because they will not lend their aid to such a plaintiff. So if the plaintiff and the defendant were to change sides, the defendant was to bring his action against the plaintiff. The latter would then have the advantage of it, where both are equally at fault, potioris conditio defendentis. And if I just take that and give you an example, if in this case, the counterclaim which KPMG has for the misrepresentations and breaches of warranty made to it, entitled KPMG to an indemnity, that indemnity would not extend to the fines which were imposed on KPMG, even if the court otherwise held that he was entitled to a full indemnity. And that is because the fines fall within the policy exception. So can we now go to, please, to Gray.
Yes.
And just struggling with, yes, is yeah, starts at 2887. I don't know if Your Honour had looked at this in preparation at all.
Did. Yes, I did. Thank you.
In that case, I'll take it relatively shortly. We know this was a plaintiff who was injured in a train accident and then tragically went on to commit manslaughter, which was reduced by diminished responsibility from murder, but it was an act for which he was responsible. And if we look at the holding, by reason of the need to avoid inconsistency in the justice system, as a manifestation of the public policy expressed by the maxim ex turpi causa non oritur actio, a civil court would not award damages to compensate claimant for an injury or disadvantage which the criminal courts had imposed on him by way of punishment for a criminal act for which he was responsible. Such policy therefore precluded a claim for damages for loss of earnings after imprisonment for an offence, notwithstanding the tortious act had led the claimant to commit the offence, since the criminal court by its sentence had found the claimant to have had personal responsibility for the crime, and it would be inconsistent for a civil court then to compensate him for the consequences of that act, even if it acted with diminished responsibility. Moreover, the fact the claim for loss of earnings had arisen prior to him carrying out the criminal act, so wouldn't prevent him from work in any event, didn't entitle him to damages for loss of earnings, both on the ground of causation, and the court could not disregard the fact he'd been detained, couldn't work, and on the ground of public policy, it would fall within the ambit of the policy precluding recovery on the ground of consistency, which required the civil court to acknowledge the criminal court had deemed it necessary to impose a sentence of imprisonment or a hospital order which removed the claimant's earning capacity. Now, in this particular case, if we go to internal page 1344, which is at 2892, this was all set down for trial, but if you look at paragraph 5, paragraph 4 in his judgment, the judge noted the trial had been set down for 5 days. On the first day of the hearing, counsel agreed he should determine the point of principle as to whether, as the defendant contended, the claim was precluded on grounds of public policy. On the basis facts set out in the skeleton argument were essentially accepted without the need for any live evidence. And then the issues ex turpi causa. It is precisely the kind of case. I mean, Your Honour says, well, no more facts at trial. But if you have a case which is doubled in size by the fine against the alleged losses, that is something which, if it's clear, should be got out of the way at an early stage, if it's clear enough. Now, we quote in our skeleton some of the key passages, and I'm going to take you just to look at them very quickly. First of all, at 1369, which is 2919. Actually, I'm going to start at 2917.
Yes.
Paragraph 24. When action came before Mr. Justice Flo for trial, counsel invited the judge to decide whether the claim for his loss of earnings while he was obtained hospital, general damages, were irrecoverable by reason of law based on public policy, which prevents someone from obtaining compensation for the consequence of his own criminal act. That seems to me the most accurate way of putting the question. No formal preliminary issue was directed to it. Then at 27, the question, in my opinion, is whether the intervention of Mr. Gray's criminal act in the causal relationship between the defendant's breach of duty and the damage of which he complains prevents him from recovering that part of his loss caused by the criminal act. The facts were clearly established by the evidence and the verdict of trial. One hand, but for the accident and stress disorder, Mr. Gray would not have killed, not have suffered the consequences. On the other hand, the killing was a voluntary and deliberate act. Stress disorder diminished Mr. Gray's responsibility, didn't extinguish it. By reason of his own acknowledged responsibility, he committed the serious crime. Now, in our case, the companies committed the serious regulatory offences for which they were fined. The fact, if it's proven, that the auditors negligently failed to discover the wrongdoing and take steps which, on the claimant's case, which we accept for these purposes, although we went to trial, would have in some way reduced the losses and might have reduced the fines. doesn't mean that put him in a different position to the wrongdoer in grey. And then we go to page 2919, paragraph 32. The particular rule for which the appellants contend may, as I said, be stated in a wider or a narrow form. The wider and simpler version is that which was applied by Miss Justice Flo. You cannot recover for damage which is the consequence of your own criminal act. In its narrower form, it is you cannot recover the damage which is the consequence of a sentence imposed upon you for a criminal act. I make this distinction between the wider and narrower version because there is a particular justification for the narrower rule, which does not necessarily apply to the wider version. Now, if you take that within the context of a company, where the company has rules of attribution, or the court has rules of attribution, as to whose conduct you attribute to the company, the question of whether you can recover for damage, which is the consequence of the company's own criminal or regulatory acts, is the wider form. And that may be for hearing a trial, but the narrower form is simply the consequence of a sentence imposed upon you for a criminal act. In this case, our case, it is the fine. In grey, it was the imprisonment and loss of earnings resulting from the imprisonment. We go to the next page, 2920, and there's a reference at 36 to Worrell. Plaintiff alleged an injury he had suffered as a result of his employer's negligence, changed his personality, committed sexual assaults. Court of Appeal struck out his claim, inconsistent with his criminal conviction, to attribute to the negligent defendant in this action any legal responsibility for the financial consequences of crimes which he had been found guilty of having deliberately committed. The reasoning of Lord Justice Mummery reflects a narrower version of the rule. The inconsistencies between the criminal law which authorizes the damage suffered by the plaintiff in the form of loss of liberty because of his own personal responsibility, and the claim the civil law should require someone else to compensate him for that loss of liberty. But this reasoning is not applicable to damage which a claimant may suffer as a result of his own criminal act, which is not inflicted by the criminal law, such as injury which he may suffer in the course of some criminal activity. Over the page at 2921, we get the State Rail Authority of New South Wales against Vigold, and the majority finding there in the quotation, letter E, if Your Honour would just read that.
Yes.
And then 41, the narrower rule is thus well established. The only case in which it's been questioned are those in which some judges have felt it was hard on the plaintiff, but his conduct hadn't been seen as blameworthy as all that. And then we get dissenting judgment of President Kirby. Likewise, being submitted in this case, a sentence of detention in hospital reflected the fact Mr. Gray was not really being punished, but detained for his own good. But the sentence imposed by the court for criminal offence is usually for a variety of purposes: punishment, treatment, reform, deterrence, protection of the public against the possibility of further offences. And that harks back to those reasons for imposing the fine which I showed you. It would be impossible to make distinction on the basis of what appeared to be its predominant purpose. It must be assumed the sentence was what the criminal court regarded as appropriate to reflect the personal responsibility of the accused for the crime it committed.
With great apologies for interrupting, I'm so sorry. The transcriber, I think, is in need of a break, but I don't know when is a convenient moment.
Yes, all right. Well, Mr. Fenwick, I'll leave that to you to decide.
Yes, well, what I will, if I may, finish off Scott, of
Yes.
Gray, and then we can move on from there. And if we go to 2922,
Yes.
I just want to look at this. The Court of Appeal rightly held it was bound by the decision in Clooney's case to apply the rule, reject the claim for damage suffered in consequence of criminal court sentence to detention. The Master of the Rolls, giving the judgment of the court with regret, seems to be something to be said for the view the traditional harsh view of public policy should be revisited in the case in which the crime relied upon was itself caused by the tort. In times, and that's caused by the tort rather than not prevented by the tort. In times gone by, it would perhaps be seen as inconceivable the murder or manslaughter of another could have been caused by a tort. Facts and evidence in core, and perhaps a more developed understanding, shows no longer inconceivable. Far from clear to us why the ends of justice are not sufficiently served by the principles of foreseeability, causation, and contributory negligence. So that's the wider approach. This argument treats the whole question as being whether the crime can be said to have been caused by the tort. As I've said, there's no dispute there was a causal connection between the tort and the killing. The evidence which the judge accepted was but for the tort, Mr. Gray would not have killed. But the rule of public policy invoked in this case is not based on some primitive psychology which deems mental stress to be incapable of having a connection with subsequent criminal acts. It may reflect more than one facet of public policy. It's sufficient in the present case to say the case against compensating Mr. Gray for his loss of liberty is based upon the inconsistency of requiring someone to be compensated for a sentence imposed because of his own personal responsibility for a criminal act. Now, finally, if we go on to 2924, and paragraph 50, this is not sufficient to dispose of most of the claims which are subject to the appeal. Claims for loss of earnings after his arrest, for general damages, conviction and damage are all claims for damage caused by the lawful sentence imposed upon him for manslaughter, therefore fall within the narrower version of the rule, which I'd invite your lordships to affirm. But there are some additional claims which may be more difficult to bring within this rule, such as a claim for an indemnity against any claims brought by dependents of the dead pedestrians, and the claim for general damages for feelings of guilt. Neither of these was a consequence of the sentence of the criminal court. They were something different from the sentence, or in our case, the fine. I must therefore examine a wider version of the rule applied by Mr. Justice Flo, support of the reasoning of the Court of Appeal in Clunis. It differs from the narrow version in at least two respects. First, it cannot, as it seems to me, be justified on the grounds of inconsistency in the same way as the narrower rule. Indeed, the wider rule has to be justified on the ground it's offensive to public notions of the fair distribution of resources, that a claimant should be compensated, usually out of public funds, for the consequences of his own criminal conduct. Secondly, the wider rule may raise problems of causation, which cannot arise in consequence with a narrower rule. The sentence of the court is plainly a consequence of the criminality for which the claimant was responsible. Other forms of damage may give rise to questions about whether they can properly be said to have been caused by his criminal conduct. So again here, although the matters for which the fine were imposed, those regulatory breaches, gave rise to losses which the claimants seek to recover from my clients in the rest of the action, those losses were not in themselves caused by the fines. They weren't in themselves caused by the decision of the regulator. They were caused by the underlying breaches. And that's why there is a difference. And I'll demonstrate why that matters, and also why it applies as much to companies as to individuals after the break.
All right, thank you. How long should we break for? Obviously, the transcriber, I didn't know there was a transcriber. I'm sorry, I thought we're taped. But if there is a transcriber, 15, 20 minutes, half an hour? Mr. Montague-Smith, are you able to proffer an opinion as to how long the transcriber might need?
I don't know, I'm afraid. I just passed on a message that was passed to me.
Right.
So, but 20 minutes should be fine, I would have thought.
20 minutes? All right, well, let's resume. It's almost to the hour, so let's resume at 20 past the hour, whatever the hour happens to be, wherever you are. So we'll resume at 20 past the hour then. Leave the lines open in case there's any technical issues, but perhaps turn cameras and microphones off. But we'll resume for 20 minutes. Thank you. Yes. When you're ready, Mr. Fenwick.
Thank you, my lord. Well, Your Honour, we've looked at two cases which set out the principle, in particular Gray, which sets out the narrow rule in clear form. I just want to look at a couple of the earlier cases, because one of those considers the question of a company, not quite in the same way as it's raised in here, but it actually shows that it's not simply a criminal regulatory punishment of an individual, which gives rise to the public policy. So if we can look at our Leslie Limited against Reliable, that's in the bundle at 2023. It's an old 1915 case, which simply shows how well established the rule is. And if Your Honour has the head note, you see that the plaintiffs were moneylenders and a company. As such, issued from time to time circulars to the public, employed the defendants to address and send out circulars on their behalf. No circular was to be sent to a minor. Owing to the negligence of the defendants, a circular was sent to a minor, and the plaintiffs were convicted and fined under Section 2 of the Betting and Loans Infants Act 1892 and Moneylenders Act. They tried to get an indemnity from the defendants because, of course, as you see, it was the defendants who had actually caused the problem by being negligent and sending out the circular to an infant. If we go on to page 657, which is 2028. And we just look at the second paragraph of the judgment. By this contract, the defence undertook to address money lenders' circulars to the persons whose name appeared in Kelly's handbook. 15 shillings was paid in respect to the deletion of minors. Work was done a little over 20 hours. 32,000 names to be examined. The name of an infant was left undeleted. Circular was sent to him. The plaintiffs and the manager were convicted and fined. Contended for the plaintiffs, the contract of the defendant was absolute to omit minors, not merely to exercise care. Left the question to the jury. They found the mistake was due to want of due care. In either case was a breach. We then go to the next page, 2829, 5 lines down. I confess when I saw the nature of this action, I formed and indicated a strong opinion that was misconceived. On the broad ground, a person convicted of a criminal offence could never have the assistance of a civil case to ease himself of the punishment by the recovery of either of the amount of any fine or costs, our case, or of damages to compensate him for any imprisonment. No difference to cases where the legislature made an act or default punishable as a crime without the existence of a guilty mind and any other class of offence. So in other words, applies also to cases of strict liability. But he then looked at authorities going the other way, and at 2030, he looks at boroughs and roads halfway through the page, and just before the second hole punch, the learned judge went on to express the opinion in cases of which he gave 2 instances where a person may be convicted as a criminal without a guilty mind, he might recover damages in respect of the penalty imposed. The case he mentioned was serving a drunken person with liquor, keeping 2 or more lunatics without registration or license. And he then looks at a number of other cases and goes on at, and this is the important bit for this, at 2032. For the reasons given above, if it had not been for the views expressed by Kennedy J, I should have decided this case against plaintiffs on much broader grounds than I'm about to set forth. Seems to me, however, giving the fullest effect to all that was said, the action fails. To begin with, if Kennedy J's explanation of Colburn is correct, the case is precisely within it, for the plaintiffs were convicted by virtue of Section 5 of the Moneylenders Act of knowingly circularising the infant. Secondly, if the substance is looked at, what the plaintiffs were convicted of was sending the circular without having reasonable ground for believing the addresses to be of full age. They knew what ground they had, namely their contract with the defendant, and it was insufficient. They knew the facts which constituted the offence. It is not to the point to say the defendants contracted to omit the minors, and cannot be heard to say the plaintiffs had not good ground for believing every recipient of the circular of full age. The action fails on the ground of the plaintiff's illegal actions, whether the defendants do or can allege it or not. So here we have a case where the court was looking at whether you can have a case where there is no fault on the part of the convicted person because it's an offence of strict liability. And I accept that there may be cases of strict liability where there is an argument open to a claimant that because he has committed no wrongdoing at all, and it was all done by a third party, then he should still be able to recover. But in this case, the offence was knowingly circularising the infant, and there were no reasonable grounds for believing the addressee to be of full age. Now, I've already shown you sufficient of the 2 fine decisions of the regulatory authority and the fines imposed for it to be clear that there was wrongdoing on the part of the company. Now, even if the claimants were to establish at trial that the wrongdoing was limited to a number of individuals who, for other and wider claims not arising out of the fines, were not to be attributable to the company. That's the Stone and Rails, Patel and Mercer line of authority. Nevertheless, there can be no doubt that permitting the wrongful conduct which is complained of and its seriousness, there was fault on the part of the company. This was not a case where a wholly innocent company, including all its officers, were, if you like, deceived into committing an offence by the actions of an independent third party. It's not a case where my client KPMG has said, you can do this, it will not be an offence. And they reasonably believed that they could do that because it was not an offence. And it turned out to be. That's not the nature of the liability imposed by the DSA. Can we go on next to look briefly at ASCII, which is in the next tab at yeah, there we go. Page 2034. This is again an old case of Mr. Justice Denning when he was a first instance judge in 1948, and we see it just below letter E. Well, let's start at the principle. It's a principle of our law. The punishment inflicted by a criminal court personal to the offender. Civil courts will not entertain an action by the offender to recover an indemnity against consequence of that punishment. Every criminal court, the punishment is fixed, having regard to the personal responsibility of the offender in respect of the offence, to the necessity of deterring him and others from doing the same thing again, to reform him, cases such as the present, to make him and others more careful in their dealings, to make him choose with more discrimination his suppliers of servants, and so on. All these objects would be nullified if the offender could recover the amount of the fine and costs from another by process of the civil court. And that's a general proposition. It is not limited to individuals. It extends to companies. The facts: from December 43 onwards, the defendant supplied large quantities of liquor for cocktails to the plaintiff. He resold it to retailers, or it sold it to retailers. The defendants were charged with selling for human consumption liquid contaminated with methylated spirits. They were all fined. 2 of them was being sentenced to terms of imprisonment. The plaintiff was assured by the defendants their conviction had nothing to do with them, went on dealing with them. In January 1945, the plaintiff was himself convicted of selling cocktails unfit for human consumption. They all had methylated spirits in it, fined £316. Consequence of this conviction, all bottles in the hands of retailers were returned to the plaintiff. He had to refund £1,735. If we then go to 2036.
Just before you leave that, it seems there, just looking at the head note, although the plaintiff wasn't a party, as a result of to the conspiracy to do an unlawful act, he'd been guilty of gross negligence. So is that saying that there has to be some fault on the part of the claimant?
No. There is a provision we'll see when we look at the case of Osman, and there's some references to it in the authorities, that where it can be shown that there was no fault on the part of the claimant, the rule may not apply. It's not a matter of lesser fault or comparative fault. Now, that can only, first of all, exist in cases of strict liability, because if there's no strict liability, there must be some fault. But even in cases of strict liability, where there is in fact fault on the part of the entity, and that includes acts done on behalf of the entity by its servants, then the defence does not apply. And that's what we saw, for example, in that last case of R. Leslie, where the company was at fault. The company didn't actually make the mistake, but the company didn't take sufficient care as held by the court, and therefore could not be absolved from the offence, because it was an offence of knowingly circulating the infant. And of course, if you think back to what we looked at, a number of the matters for which fines were imposed were for deliberate and conscious misleading. Now, that's an act of the company. So I hope that answers the point. If we can go to the very bottom of 2036. The personal defendants were not liable for the company's breach of contract. They are liable for their own torts. Clearly under a duty to be honest, they broke the duty. All three guilty of a conspiracy to do an unlawful act to put methylated spirits. As a result, the plaintiff did suffer the damage he claims. So, clear case of the damage being caused by the defendant. But the important question is whether in law he can recover in respect of that damage. He was himself guilty of criminal offences in selling this liquid to the retailers. Abraaj companies were here guilty of the regulatory defaults for which they were found liable. Is he to be allowed to come to this court and ask to be indemnified? He was not himself a party to the conspiracy. I'm satisfied he was much to blame in that he didn't take proper steps to see the liquid was fit for sale. Even after he knew 3 men had been convicted, 2 of them gone to prison, he went on dealing with the third one, dealt on a large scale. Didn't have the stuff analysed. He was, I find, tempted by the large profit he was making to take a risk on it. Suit him to accept the assurances. The view of the fact is confirmed by the convictions recorded against him. If he could have proved that he had used all due diligence and that he had no reason to believe that the liquid was contaminated, he would have had a defence to the summonses and he could have thrown the responsibility onto the company and 3 other defendants. He didn't even bring the Golden Wine Co. before the Justice Court, as he might have done if he alleged the contribution was due to their act or default. In these circumstances, the conclusion is irresistible that although he was not a party to conspiracy, he was guilty of gross negligence. What's the consequence of this finding? I'm clearly of the opinion the plaintiff cannot recover any of the fines imposed on him by the justices, nor the costs he was ordered to pay, nor his own costs, nor damages for the consequence of the convictions so far as they affect his reputation. So all related to the conviction. It is, I think, a principle of our law that punishment inflicted by a criminal court, personal to the offender, civil courts will not entertain an action by the offender to recover an indemnity against the consequence of the punishment. In every criminal court, the punishment is fixed, having regard to the personal responsibility of the offender in respect of the offence, deterrence, reform, etc. And you've seen how, in this case, the penalties imposed on the companies, as opposed to those imposed on KPMG and on certain of the officers of the company, were imposed on the companies for their own participation in the fault. Now, if the position had been that Abraaj could have shown that they were free of any misconduct or negligence, that the company, and whether that was through innocent directors or overall, then they could have said that, and they could have taken the opportunity to make those representations. They didn't. And the reason they didn't is because the existence of such widespread fraud, even if not known to every director, was something that the directors had a duty to discover by reasonable care and diligence. It's even said by the claimants here that this was not a sophisticated fraud. So there's no question here of them ever being able to show that they were wholly innocent and wholly without any fault. And indeed, Mr. Hubble doesn't even attempt to do so. Now, we can move on a little beyond that. And I want to look with a little bit of care, if I may, with you at the Safeway stores case, because it's much misunderstood by my learned friends and sometimes by others who take a throwaway line from Lord Sumption in a later case, referring to his involvement in that case in classic Sumption style. The case of Safeway in the Court of Appeal is at 3136.
Yes, I have it. Thank you.
Thank you. Now, that was an appeal from Mr. Justice Flo. The claimants say, oh, well, forget the Court of Appeal. You should follow Mr. Justice Flo. Well, that's a slightly unfortunate use of precedent. But in fact, when you analyse Safeway stores, it doesn't provide the assistance which Millennium Friends seek to get from it. So I'm going to take a little bit of time. This is one of the 2 or 3 cases that I'm spending a bit of time on. You've been given a massive authority, and I'm not going to take you through it all. Most of it is irrelevant. But just looking at the head note, and again, is this one of the cases you managed to have a look at?
Yes, I have.
Good. So I can take some of the facts shortly. You'll see this was claimant companies. They were involved in breaches of the Competition Act because of prices of milk. They sought to recover the amount of the penalty by way of an indemnity from the defendant employers and directors who had been responsible for the claimant's participation initiative. Judge held the maximum didn't apply to preclude the recovery sought, refused the application of summary judgment, held allowing the appeal. The ex turpi causa maxim operated as a defence where the claimant was personally at fault. That the claimant's liability to pay a penalty was not vicarious, was personal because the penalty could only be imposed on them if they had intentionally or negligently infringed Section 2.1 of the Act. It was inconsistent with that liability for the claimant to be able to recover the amount of the penalty in the civil courts from the defendants, and that accordingly the defendant were entitled to judgment. And then we get policy of the Act is protection of the public, undermined if undertakings were able to pass on the liability to their employees or the employee's insurance. The policy of the regulations of the DIFC are to protect the public in the form of creditors and investors. And that policy would be undermined if those responsible could pass on liability to, in our case, their auditors. For these civil penalties. Now, this is a different kind of case. The cases with which Stone & Rolls, Filter, Mercer and Patel dealt with are almost all cases where there is a third party which negligently or wrongfully causes the loss by failing to uncover wrongdoing at the claimant entity. This is a case against directors where one might have expected different rules to apply, and one would normally expect a company to be able to recover from its directors for the consequences of the director's wrongdoing. Not, however, for the fines imposed on the company. Now, can we just look as we go past at, because it's important, where have we gone to? Yes, a paragraph. I've got a slightly different version. Paragraph 10, which is at 3141.
Thank you.
Claimant's pleaded case is by participating in and facilitating the initiatives, each of the defendants in breach of his or her contract of employment. Alleging breach of contract, they failed to report the initiatives to the superiors, and so on. Don't need the details. Said by the claimants, consequence of the defendant's breach of contract, they've suffered loss and damage. The principal element of the loss is a penalty from the OFT to which the claimants are exposed. Then the levying of penalties is dealt with by the various acts. And then if we look at 3 in the quote, the OFT may impose a penalty on an undertaking under section 1 or 2, only if the OFT is satisfied the infringement has been committed intentionally or negligently by the undertaking. So you only get liability if the undertaking itself has committed the infringement deliberately or negligently. If we go on to paragraph 13, still on that page, In addition to the claim for breach of contract, breach of fiduciary duty and negligence, claimants alleged defendants conspired to procure the claimant's participation in the initiatives and in furtherance of the conspiracy, carried out the anti-competitive measures which were unlawful acts. It's alleged since those were unlawful acts intended to increase the retail prices, they were aimed at the claimants. So in other words, that the defendants were acting in fraud of their own employers. Then we get the maxim 15. The first question considered by the judge was whether the contravention was sufficiently illegal or unlawful to engage the maxim ex turpi causa. He held the infringements occurred were sufficiently serious to engage the maxim. In my submission, the infringements in this case, which the fines were imposed, are self-evidently sufficiently serious to engage the maxim, and I've shown you where the regulator said that they were themselves serious. Then we get to the history and Gray and Thames Train at paragraph 16, the wider form and the narrower form. Then just for H, both versions of the rule are often in play as they are in the present case, because it said the recovery of the penalty likely to be imposed is recovery for the consequence of a sentence for the criminal act of entering into an illegal agreement, whereas the recovery of the cost of the OFT investigation is recovery for the consequences of making the illegal agreement. So here we have the narrower rule, which is all I'm interested in today, which is the penalty, and the wider rule, the cost of the investigation. The main difference appears to be there's no question of any causation problem in the application of the narrower version, whereas difficult problems of causation may in theory arise if it's only the broader version of the rule on which reliance can be placed. And it again makes this distinction that causation comes into play if and only if you're looking at the wider version of the rule and not the narrower version of the rule. Then there's Gray at 17, 18. We're now on 3142. It's not been expressly decided whether the maxim in either its narrow or wider version applies where the criminal act is one of strict liability and the claimant may not have been at fault at all. Closest case as and so what one needs in order to get into that territory is both an offence of strict liability, of which some of these are and some of them are not, and a state where the claimant was not at fault at all, which is not the position here. Then you get ASCII, and then 6-7 lines down, the problem of strict liability offences need not, however, concern the court in this case, because section 36.3 makes it clear the OFT may only impose a penalty satisfied the infringement has been committed intentionally or negligently by the undertaking. Therefore, proceed on the basis the claimants are attempting to recover damages for the consequences of an infringement committed intentionally or negligently. There is no plea here that the fines are recoverable because A, they were of strict liability, and B, the claimant was not to be held at fault at all. It's not part of the pleaded case, nor could it be. 19. The difficulty and novelty of the present case is the claimants or a corporation can only act through their human agents. So not a claim against third-party agents, but a claim against the agents who were in fact the members of the company who, through whose act the wrongs were committed. It is, if it is those human agents who've acted intentionally or negligently, have thus caused the corporation to become liable by way of penalty, does the maxim apply to preclude recovery of the penalty and its consequences from the very employees and directors whose conduct has created the corporation's liability? The judge has held it arguably does not, because it has not been shown at this stage of the proceedings, at any rate, that any of the defendants was the directing mind or will of any of the claimant companies. He thought, unless he could be shown it was impossible to say the claimant companies were personally at fault, maxim only applies where the claimant was personally at fault, as accepted by Mr. Sumption in argument in stone and rolls. And one sees here that Mr. Sumption, as he then was, floated between different arguments on different sides with consummate ease. And then says this: at this stage, it's important to recognize that the claimant's liability is not a vicarious one. They're not liable for the illegal acts of their agents or employees, because Section 36 of the Act only imposes liability on an undertaking which is a party to an agreement which infringes a prohibition. That liability can only be imposed if the infringement has been committed intentionally or negligently by the undertaking. The liability to pay the penalty is thus a liability of the undertaking, where it, the undertaking, has intentionally or negligently committed the infringement. Submits in this case, the liability is therefore a personal liability for the undertaking. Now, just pausing there, this is the company which has to be at fault. It's different from offences of strict liability. For example, allowing a person without a driving license or without insurance to drive one of the company's vehicles. The company may have known nothing of it, may be innocent, but an offence of strict liability caused by the act of the employee, for which they are vicariously liable. In those circumstances, it's their vicarious liability which gives rise to the loss. In this case, it is the act of the officers acting within their roles which become the acts of the company. Now, the muddle in this case, as interpreted and as relied on by my learned friend, comes in the next section. Mr. Robert Anderson, for the claimant, submits the companies could only be personally at fault if the infringement was committed or authorized by the board of directors acting as such, or by the shareholders in general meeting, unless there was some special rule of attribution applicable. He relied on Meridian, which the relevant New Zealand statute had provided any person who became a substantial security holder in a body called a public issuer had to give notice he was a substantial security holder. The chief investment officer of the appellant company used company funds to acquire shares in a public issuer. Neither he nor the company gave the required notice that the company had become a substantial security holder. The New Zealand Securities Commission instituted proceedings against the company for the failure. Questions whether the knowledge of the chief investment officer was attributable to the company, so the company was liable for the failure. Privy Council held the knowledge of the officer was attributable to the company, which was therefore liable for the failure. Of course, the judgment explained the law of attributability to a company in criminal law, which ordinarily exposes liability only if the actus reus and mens rea of the defendant himself. And then we get what Lord Hoffman says. One possibility the court may come to the conclusion the rule is not intended to apply to companies at all. Law created an offence for which the only penalty was community service. Another is the court might interpret the law as meaning it could only apply to a company on the basis of its primary rules, i.e. specifically authorised. In many cases which neither of these solutions is satisfactory, which the court considers the law was intended to apply to companies, although it excludes ordinary vicarious liability, insistence on the primary rules of attribution would in practice defeat the intention. It must fashion a special rule of attribution. It's always a matter of interpretation, given it was intended to apply to company. How is it intended to apply? Whose act or knowledge was for this purpose intended to count? And finds the answer by applying the usual canons of interpretation. Mr. Anderson submitted there was no need to have regard to any special rule of attribution in this case, because the ex turpi causa could not apply unless the claimants were personally at fault, and in no way could they be said to be personally at fault in this case. So this part of the argument is because Mr. Anderson is asserting that the company was not at fault at all. So therefore the company could recover. This submission misunderstands or misapplies the use of the word personally, as applied in the requirement for the claimant to be personally at fault. No one is liable for the penalty imposed under the Act except the relevant undertaking. The liability is therefore personal to the undertaking. If there's a liability, it cannot be imposed on any person other than the undertaking is personally liable for the infringement. If a penalty is imposed, it will only be because the undertaking itself has intentionally or negligently committed the infringement. In those circumstances, it's the undertaking which is personally at fault. There can be no one else who is. And once the maxim is engaged, the undertaking cannot say it was not personally at fault in order to defeat the application of the maxim. The whole hypothesis of the undertaking's liability is that it is personally at fault. So just pausing there and trying to unpack this, because it is heavily relied upon. As we've seen, and we'll see again when we look at the case of Osman, there is an open question as to whether when the company is entirely innocent, it can say, we are not at fault at all. The fault was that of another person. Therefore, the maxim should not apply to us. But for that, they have to show the fault was not theirs. Now, in this case, the fact that the company was responsible, the undertaking here was responsible for this, because it effectively entered into the wrongful conduct, whether through its officer or otherwise, then the undertaking was at fault, the undertaking was liable, and the undertaking was fined. Because of that, and because it was not an act of strict liability for which it was not at fault at all, it couldn't say, we accept the maxim, but the maxim does not apply because we ourselves were innocent. So again, it is only if Melania's friend were able to show, or had pleaded, which he didn't, that there was no fault on the part of these claimants, that they could fall within the exception to this strong, clear, long-standing, narrow rule. And they can't do that. And of course, we know they can't do that because the company has accepted responsibility for it. In one case, because it settled the complaint and got a 1/3 reduction or 30% reduction for doing so. And in the other, because the regulator found that there was deliberate and intentional conduct on the part of the company. So the company cannot rely on the narrow exception. But it's not a case of the maxim only applies where there is fault on the part of, or relevant fault on the part of the claimant. It always applies, except in certain cases where the company can show that it was an offence of strict liability and it was wholly innocent. It was deceived by somebody else. And that takes me to the case of Osman, relied on by the claimant, and that's at 2039. And we just look at the head note. Again, has Your Honour seen this?
I've looked at it not as thoroughly as some of the others. I've skimmed it. So.
Well, if I'm ever going too slowly, please tell me to speed up, and I will happily be corrected and shove on. Here we get, and there's not much we need to look at here. Plaintiff Turkish origin, ability to read and understand English was limited. On the recommendation of the defendants or insurers brokers, he signed a proposal form in respect to a motor insurance policy with Belvedere, a company whose shaky financial foundation was well known, paid a premium for cover, handed the cover note, 6 days expired. Defendants did not inform him whether or not his proposal had been accepted. On February, they received a note from the insurance company stating the insurance has been effected, winding up order made. Became clear the policy which the plaintiff had obtained was wholly valueless. Defendants read a letter to him saying, we would advise you that you are at present insured with Belvedere, suggest you insure yourself with another company. Plaintiff involved in an accident informed the defendant of you to making a claim. For the first time on June the 15th, so 4 days later, informed that he was uninsured. Fined for driving without an insurance policy, for driving without due care, incur costs of £3.10. Brought an action against the defendants claiming damages, breach of contract, failed to take proper steps to obtain cover against third parties, and alternatively in tort. Then we can go to Mr. Justice Sachs, who held in favour of the claimant. But if we go to internal page 316, which is 2042, right-hand column, first main paragraph. Next, I turn to the fine of £25. Having examined the authorities as to cases where the person fined was under an absolute liability, it appears that such fine can be recovered in circumstances such as the present as damages, unless it's shown there was on the part of the person fined a degree of mens rea or of culpable negligence in the matter which resulted in the fine. The onus in cases such as the present is on the defendant, who with a true cause sequence of events leading to the fine, to show that there are circumstances which make that fine irrecoverable as damages. So this is a long time ago, 1970. It's pre-Gray against Thames Train, which set out the law. But it's clear here that the only basis for the defence is that of no culpability at all. We're not dealing with that in this case in any shape or form. And if we just perhaps go back one page to 2041, the right-hand column under motor insurance halfway down, it's true some recipients would have regarded that as a warning, however inadequately phrased. To my mind, this particular plaintiff, whose characteristics were known to the defendants, would simply not convey the warning which would have been given, indeed, it would not have conveyed the warning to a great number of people. Say somebody you're insured when in fact he's uninsured is calculated to mislead. So it was a very strong case, an exceptional case in which the claimant was entitled to recover. I want to look at one more case on which the claimants rely, because again, it's clear that they place a weight on it which it will not properly carry. And that is the decision of Mr. Justice Voss, as he then was, in Griffin and Hacker Young, where my learned friend Mr. Hubble was, I can say, on the wrong side again. He was on the other side for the defendant and unsuccessfully failed to get the claim struck out against yet another member of the same chambers as both of us, now Mr. Justice Sewell, who prevailed. That's at 3120. Just looking at the head note, claimants had a company known as Saxon Drinks, of which he was sole director, to make a drink known as Saxon 1050, went into insolvent liquidation. Claimant consulted a partner in the accountancy firm, operated a turnaround recovery unit, starting a new company. New company registered, didn't become a director, ceased to hold office. And then after 2 warnings from the Insolvency Service, he was charged under Section 216, the Insolvency Act, with taking part in the management of a company with an apparent connection with Saxon Drinks. He was convicted and fined £1,000, an appeal being dismissed. In 2009, he brought proceedings against the defendants, alleging that A's advice as to whether he could be involved in Brand Central had been negligent, claiming as damages the losses allegedly resulting from his conviction, including the loss of his substantial shareholding, loss of earnings, earning capacity, the costs of the criminal proceedings, and his personal liability for the debts. Defendants applied for summary judgment. Summary judgment should be refused, the action allowed to proceed. The gravamen of G's suits was not a claim for the direct consequences of the fine imposed upon him for a breach of the Section 216 of the 1986 Act. That's very important, because the very thing which is our case here, recovery of the fine, was not part of the claim in Griffin, as my learned friend Mr. Hubble may have remembered. It followed that the issue was how far a claimant could claim in respect of the general results of a criminal conviction. So that is the wider rule in Gray. On the authorities, it was clear a claimant would only be barred from claiming such a case if a degree of serious culpability was shown. It was probable but not certain that negligence was not enough for this purpose. Gray and Safeway stores discussed. Now, it's quite important to bear in mind that this decision of Mr. Justice Voss in February of 2010 came between the finding of Mr. Justice Flow at first instance in Safeway, when he said the claim could proceed, and the finding of the Court of Appeal, when the Court of Appeal, through Lord Justice Longmore, held that it couldn't. So he was following, as we'll see, a position which was overruled by the Court of Appeal in the case I've just shown you. Now, we can run a fair way through this before we need to look, which is at 3126, paragraph 32. And Mr. Hubble finds his case squarely on the dictum of Lord Hoffman in Gray against Thames Train, where he approved a formulation of the ex terpi causa in both its wider and narrower form. That's all set out. Mr. Hubble says the losses claimed by Mr. Griffin all fall squarely within these rules as being both damages flowing from his conviction and penalty and losses suffered in consequence of his criminal act. Mr. Sewell responds by saying it's an offence of strict liability, on which only takes effect if the action is prohibited, not legalised by either obtaining the permission of the court or serving a notice. And then talks about ex terpi causa, when you sue him for damages, only if you're guilty of moral turpitude, and not if you're simply guilty of a strict liability offence, even if you knew all the facts. Required level of culpability connected to the question of causation, and so on. Mr. Hubble, in that guise, accepted to rebut the fact the offence is one of strict liability. In fact, it's not alleged Mr. Griffin knew of the existence of the offence. He needs to show personal fault on the part of Mr. Griffin. He also accepted in this case, but not generally, the species of personal fault that was relevant was moral culpability rather than gross or any lesser species of negligence. Argument boiled down to saying, because Mr. Griffin has admitted certain elements of his conduct, his claim is bound, whatever the evidence of trial, by terpi causa. He then sets out the things that he relied on. Then at 3128, Mr. Sewell's answer is submit this conduct may be shown at trial to be part of a well-hatched plan. It may be shown to be morally culpable. Equally, it may turn out Mr. Griffin to give a valid explanation. It must be a matter for the judge to decide at trial. Put the matter forensically by saying Hacker Young say Mr. Griffin deliberately did not comply with the law, wanted to go ahead with the scheme regardless. Mr. Griffin says he wanted to comply with the law but was badly advised. Trial is necessary. And then we get on to the issues. Summarise as follows. Precise scope of the narrow role of public policy as described by Lord Hoffman. The question is whether the narrow rule is that a claimant cannot recover for damage which flows from a sentence lawfully imposed in consequence of his unlawful act, or whether the rule also encompasses any losses flowing from the conviction for that unlawful act. So damage which flows from a sentence lawfully imposed is, for example, will include the fine. This is important because Lord Hoffman made clear, if the narrow rule applies, then problems of causation do not arise, as they do if only the wider rule is applicable. In this case, of course, some at least of the losses claimed by Mr. Griffin may be argued to have flowed from the conviction under section 216, but not from the £1,000 fine imposed. So what was being said here by the judge is that Mr. Sewell had effectively persuaded him that some of the matters claimed did not arise from the £1,000 fine, but arose from something else. It was not a consequence of the fine itself. That's because his inability to recover his shareholding, his loss of earnings power arose from his conviction. A rider to the first issue is whether, if the narrow rule applies at all, is applicable in this case, the second or third issues that I describe below arise at all. Second issue is the level of the claimant's culpability. The third issue is no real prospect of defeating the pleaded defense. So he's saying is if the narrow rule is applicable, do those arise at all? In my judgment, the answer to the issue is clear from the decision in Gray and Thames Trains, from the rationale of the rule examined. I do not intend to read Lord Hoffman's formulation. His formulation of the narrow rule and the references to it by other members of the committee seem to me to demonstrate clearly the narrow rule only applies to losses flowing from the sentence imposed. So that's losses flowing from the sentence, not of the wrongful act which gave rise to the sentence. Lord Hoffman describes a narrow rule that you cannot recover for damages which flows from the loss of liberty, a fine, or other punishment lawfully imposed upon you in consequence of your own unlawful act. Various speeches all reinforce this definition in referring to the rule in terms it applies to losses flowing from the sentence imposed by the court. Mr. Hubbell's argument turns on what Lord Hoffman said in the following passage. Mr. Gray's claims for loss of earnings after his arrest, for general damages for his detention, conviction, and damages, are all claims for damages caused by the lawful sentence imposed upon him for manslaughter, therefore falls within the narrower version of the rule. He submits that since the reference to general damages, the rule must be wider than originally stated. I disagree. On the facts of that case, there can be no real distinction between general damages for the conviction and general damages for the sentence compensation was claimed for the fact he was detained. Moreover, the rationale of the narrow rule is it's inconsistent for the civil courts to compensate a claimant for a penalty adjudged to have been imposed for the personal fault of the claimant. The conviction itself, particularly of an offence, may not carry any personal fault, so the inconsistency rationale cannot apply anywhere in all cases to it. The consequence of this holding, it seems to be the most significant losses claimed by Mr. Griffin. In this case, at least the shareholding in OFC and the loss of earnings do not fall within the narrow formulation of the rule, as having flowed from the fine of £1,000 imposed upon Mr. Griffin. So he's distinguishing here between the fine and matters which derive from the fine, which are barred by the narrow rule, and other losses. It's necessary to consider whether they all fall within the wider rule. I do not need in these circumstances to consider whether, if all the losses had fallen within the narrower rule, the remaining issues would have arisen at all. So he's not dealing here with the narrower rule. He's dealing with the wider rule. And when we come to, after his analysis of the cases, we go to 3133. Paragraph 59. Against the background of these cases, I have considered carefully whether I should decide what level of culpability will be necessary in this case for the defence of ex turpi causa to succeed. I've informed the view I should not. This is because, as appears below, even in the agreed formulation of moral culpability, I regard as impossible the defendant to succeed in showing at this stage there's no real prospect of Mr. Griffin defeating the defence of ex turpi causa. If I'm right about that, my decision on the level of culpability required to be gratuitous and unnecessary might tie the hands of the trial judge, who will be able to decide the points on the far more satisfactory basis of concrete findings of fact he would have made, having heard the evidence. I will make 3 short observations. None of the existing cases have raised the question I have formulated after a trial and analysed the legal question as a matter of law and principle. Formulated to speak with one voice. May very well be the level of culpability will depend on the offences relied upon it. Then this. I agree with Mr. Justice Flo, that's Mr. Justice Flo at first instance in Safeway, overruled by the Court of Appeal. The use of the epithets gross, culpable, or crass to describe negligent or unhelpful. Use of these epithets to belie the fact the court was searching for some ill-defined culpability. And then in my judgment, the question of the level of culpability required to support an ex turpi cause of defence based on strict liability is intimately bound up with the issue of causation described by Lord Hoffman in Gray and Thames Tray. Now, it's that question of causation which applies on the wider rule, but does not apply on the narrow rule. So what is clear here is that the judge was allowing the case to go forward, not on the basis of the recoverability of the £1,000 fine, but on the question of whether some of the other losses claimed were consequences of the fine or not. And I can take this example from our current case. If part of the claim had been as a result of the fines imposed, there was a flight from investors causing the collapse of the company. In one sense, it could be said that that flight of the investors was caused by the regulatory findings, conviction and fine. On the other, it engages a wider question of causation. Such a claim is not being made in this case, and I'm not trying to strike it out. I'm limiting myself to striking out a claim for the fine itself. Now, the last case that I want to look at is the case of Henderson in 2021. Henderson is important because my learned friend, as you've seen, places very substantial reliance on all the Patel and Mirza line of cases. We all know Stone and Rolls was fascinating for its complexity and a case to be looked at only on its own facts, as opposed to some guiding matrix. And Lord Toulson in Patel and Mirza laid down a test for when you attribute the knowledge of a wrongdoer to the company for the purpose of deciding whether that wrongdoing bars a claim by the company against a negligent third party, such as an auditor. And all those cases will come into focus at trial when we deal with that wider part of the case. They do not have any role in looking at the narrow rule, which survives. And we can tell that the narrow rule survives by looking at Henderson. That is at 3850. Yes, I mean, I referred to Patel and Mirza about attribution because Patel and Mirza is the question of what a type of wrongdoing on the part of the company will bar a claim ex turpe causa, it's singularis, which deals expressly with the question of attribution. In Henderson, which, as I say, is at 3850, we get another tragic case of a claimant not well looked after by the NHS, who had a history of schizophrenia and unfortunately killed his mother. Then if we go to the second page, 3851, and the holding. Although Patel and Mirza concerned a claim in unjust enrichment, the trio of considerations identified by the Supreme Court in that case gave guidance as the proper approach to common law illegality defence across civil law generally. However, since that guidance was derived from pre-existing case law, earlier decisions on the illegality defence remained of precedential value unless it could be shown they were not compatible with that approach, in the sense that they could not stand with the reasoning in Patel and Mirza, or were wrongly decided in the light of that reasoning. Since Gray and Thames Trains had been decided by reference to public policy considerations, namely the need to avoid inconsistency between the criminal and the civil law, the need to avoid undermining public confidence in the law, it was compatible with the trio of considerations approach. That further, since Gray had been decided by reference to the fact the claimant had been found to be criminally responsible, rather than by reference to his degree of personal responsibility, the present case could not be distinguished on the ground the claimant bore no significant personal responsibility. 2. Dismissing the appeal, public policy reasons which supported denial of the claimant's claim included 1. The need to avoid inconsistency between the criminal and civil law, which consideration was heightened by the very close connection between the claimant's claim and the illegality, the need to maintain public confidence in the law, significance which was heightened by the gravity of the claimant's wrongdoing, public interest in proper allocation of resources, public interest in deterring, protecting the public from, and condemning unlawful killing, no countervailing policies that outweighed those considerations. In any event, denial of the claim would not be disproportionate, having regard to the seriousness of the claimant's unlawful conduct, centrality of the conduct of the heads of lost claims, and so on. And we can then, I think, go directly to the judgment of Lord Hamblin, which is at internal page 610. And if we go to, I think 39, see if, give me a moment if you would. Let's get a bit of trouble with the pagination. Yes, my system wasn't bringing it up. If we go paragraph 59, which is on 3903, where he says the consistency principle applies to both the narrow and wide claims in Gray, as supported and explained by Lord Sumption in his dissenting judgment in Patel. The inconsistency of awarding damages representing loss arising from a criminal sentence is more obvious and direct than it is when the claimant is claiming other damages causally flowing from his commission of a crime. But it seems to me that it's Justice McLaughlin and those who have adopted her approach more generally, the internal coherence of the law is also the reason why it will not give effect in a civil court to a cause of action based on acts which it would punish in a criminal court. The law must act consistently. So that's again dealing with this wider point about the cause of action based on acts it would punish, so i.e. the underlying acts rather than the fine itself. The Supreme Court goes on at paragraph 61 to deal in some detail with Patel and goes through it in detail. And then at 3906, Lord Hamlin starts to apply Patel at paragraph 73. Important issue which arises concerns the width of the application of Patel, how it applies in relation to existing case law. First, it should be emphasized Patel concerned common law illegality rather than statutory illegality. Where the effects of illegality are dealt with by statute, then the statute should be applied. Lord Toulson stated the court must obviously abide by the terms of any statute. In relation to contractual illegality explained by Lord Justice Underhill in Ocadena. Then he goes on to 76. Patel concerned a claim of unjust enrichment. Can little doubt it was intended to provide guidance and proper approach, common law illegality defence across civil law more generally. Includes tort law cases, Tinsley and so on. Thirdly, that doesn't mean Patel represents year zero. In all future illegality cases, it's Patel and only Patel is to be considered. That would be to disregard the value of precedent built up in various areas of law to address particular factual situations giving rise to illegality defence. Those decisions remain of precedential value unless it can be shown they're not compatible with the approach set out in Patel, in the sense they cannot stand with the reasoning in Patel or were wrongly decided in the light of that reasoning. Lord Toulson made clear in Patel the principles he identified were to be found in the existing case law. Then if we go on to the next page at issue 6.1, whether grey can be distinguished, a number of arguments for distinguishing it, and at paragraph 86, in my judgment, grey cannot be distinguished, involve the same offence, same sentence, reasoning that the majority applies regardless of the degree of personal responsibility for the offending. Then at 89, the appellant argues the decision in grey as an example of the now discredited rule-based approach to illegality, the Tinsley and Milligan approach. It's contrary to the flexible policy approach endorsed in Patel. It does not allow for the court to take into account the particular circumstances of the case, such as the degree of the claimant's personal responsibility, nor does it allow for consideration of proportionality. In my judgment, the essential reasoning in grey is consistent with the approach adopted in Patel. Grey did not involve the reliance-based approach, nor did it follow or apply Tinsley and Milligan. Lord Hoffman says such an approach was not helpful in their case, had nothing to do with whether the rule of law for which the appellants contend. Then if we go please to 3912, paragraph 105. As explained above, the key consideration, as far as the majority in grey was concerned, was claimant to be found to be criminally responsible for his acts. Convicted of manslaughter on grounds of diminished responsibility meant responsibility was diminished but not removed. In such circumstances, the majority justifiably considered inconsistency would arise, not only if he was allowed to recover damages resulting from the sentence imposed, but also if they resulted from the intentional criminal act for which he had been held responsible. To allow recovery would be to attribute responsibility for the criminal act, not as determined by the criminal law to the criminal, but to someone else, namely the tortious defendant. there is a contradiction between the law's treatment of conduct as criminal. The acceptance such conduct should give rise to a civil right of reimbursement. The criminal under the criminal law becomes the victim under tort law. He then goes on at 111 to say it's not sufficient simply to say it's been a matter for the trial judge to determine. 112, the related argument, the lack of significant personal responsibility by the individual, in this case by the company, insufficient turpitude to give rise to an illegality defence, and removes that. And then we can get to the conclusion at 145, 145, which is page 3918. The appellant has not shown Gray should be departed from. On the contrary, the decision Gray should be affirmed as being Patel compliant. How Patel plays out in a particular type of case. The clearly stated public policy rules set out in Gray should be applied and followed in comparable cases. Now, Your Honour, all those cases which I've taken you through at some speed consistently show that the narrow rule, which is the inability to recover for a penalty in the form of a fine or imprisonment, applies and bars the claim as a matter of public policy to uphold the respect for the laws which are engaged in criminal laws and in regulatory laws. Nothing in Patel and Mirza disturbs that policy. There isn't a case in which it has been held that a fine or other regulatory or criminal punishment can be recovered, apart from Osman, which was a pre-Gray case in which there was strict liability and a finding of no personal liability by the claimant at all. If it were necessary or if the claimant had asserted that there was no wrongdoing by the company, then it would have opposed successfully the fines imposed on it. It was because there was wrongdoing by the company for which the company was personally liable that the rule applies. It is different from the question of purely vicarious liability, where the only liability arises from the conduct of the agent or employee and not the company itself, and where those acts are not attributed to the company. When you have a chance to read again in considering my submissions, the two judgments or decisions on which the fines were based, you will see that it's based broadly on the acts of the company, not on specifically the acts of individual wrongdoers who are identified and for whose actions and knowledge the company is held responsible. The company is responsible. The public policy is to punish the company. And to say that in order to protect creditors, the company should be able to recover the fines which, after careful consideration and as a deterrent for them and for others, had been imposed, goes in absolute contravention of the rule as expressed as the narrow rule in a Gray against Thames Train. And if one thinks about it, in this sort of case, that that's precisely why the fine is imposed. It's precisely why the fine is different to the fine imposed on KPMG. If KPMG were forced to pay out not only its own fine, but the company's fine, that would be double punishment, and it would defeat the public policy. Now, Your Honour's quite understandably made the point that the ultimate losers here will be the creditors, as in any insolvency. But as Your Honour is only too well aware, in this kind of case, in an audit case, there are rules as to the scope of the auditor's duty, as to remoteness of damage, and as to when the ex turpi causa rule applies. And it is not an answer to that to say, as Lord Mance did in his dissenting judgment in Stone and Rolls, when the company is insolvent, then the duty of the auditor becomes to the creditors, not to the company. The duty is owed to the company, and it's only for those breaches of duties that the auditor is responsible. In this case, for Your Honour to say, it is arguable that where the creditors will suffer, some different rule should apply, flies against the rule in Gray, and indeed against, in particular, the rule in Safeway. In Safeway, by the time the fines were imposed and the claims came to be made, ownership had changed. It had been bought by Morrison's, management had changed. And of course, the people who were suffering were in that case, the shareholders, because it was solvent, but it would equally have been the case if the company had been insolvent, the creditors who would have suffered. That was not considered and should not be considered as a defence to the narrow rule. Now, Your Honour, can I just stand back and see where I've got to and what I've missed out, because I've taken that at some pace. And I should just, and I can do most of this by reference to my skeleton, if you have that
Yes, I do.
available to you. And I'm using the internal pagination, if I may.
Yes.
In paragraph 32 on page 9, we draw attention to the veggie bar case. Very different kind of case, but it's a case which acknowledges that on grounds of illegality, immediate judgment can be given. The defence is available in, for example, Article 56. I will deal with my learned friend, Mr. Hovell's answer trial point, if he makes it, in reply.
Yes.
Again, we say that's not well founded. And of course, we have the yes, at seem to have a network failure in my case bundle. So I'll have to do it another way. Yeah, no doubt I can sort that out in due course. We have do it another way by reference. Yeah, to the Judicial Authority Law, Article 6, which, as Your Honour well knows,
Yes.
says the court shall apply the centre's laws and regulations, except where parties to the dispute have explicitly agreed another law shall govern, provided such a law does not conflict with the public policy and public morals. So public policy is very much a feature at all levels. It's worth turning to page 11, paragraph 41. That was a financial service. Khan was a financial services act authority sanction, failing to comply with the UK's financial services regime. The accountant in part caused the imposition of the sanction. That was not recoverable because the claim which was dismissed was Pursuer's claim for damages for loss of profits from being unable to supply financial services. And that, of course, is because they had been sanctioned. So it was a direct result of the sanction. So it applies in a regulatory case. At page 13, I underline at paragraph 47 onwards, the public policy reasons for imposing fines and for not allowing those fines to be recovered, even on the in misericordiam argument that actually it's poor old creditors who suffer, as opposed to the company. This public policy, in short, is not made by considering on whom the loss falls in the case of insolvency. It's based on the principle that a fine imposed on a company for wrongdoing by the company, which is not one in which they can show that they were entirely innocent of any fault, is barred by the narrow rule. And we say at paragraph 52 on page 14, the incoherence between the regulatory law and the civil law. And Your Honour has my submissions in that section. I deal with causation issue, page 15, paragraph 58 onwards. And this case that they make, they're only recovering for the ones which would not have been caused, would not have been incurred had the defendants not been negligent. There are two important things which emerge from that proposition, which I showed you in the reply and which my learned friend majors on. First is this, that the illegality defence will apply in many cases to fines where there is fault on the part of a third party, because the claim wouldn't have been brought otherwise. And that's Leslie, Askey, Gray, Safeway, Khan, Henderson. There's always a third party who is negligent. Causation doesn't enter into the narrow rule, as I've shown you. The second, well, there are 3 points really. The second point is what that is really telling you about this case. They're only claiming for those parts of the fine which would not have been incurred had the defendants acted with reasonably promptly. So it accepts, and this is important, that part at least of these fines were imposed because of fault which had nothing to do with my clients. So they are not innocent. That in itself defeats the argument that we're dealing here with innocence. What is really being said is this. Yes, there is fault on the part of the company for which the company was fined and which it would always have been fined. That bit, we know we can't recover, we don't seek to recover. But what we say is that if the defendants had not been negligent, that would have prevented that misconduct continuing. It doesn't say the further fines were caused by the conduct of the auditors. It says they were not prevented by the conduct of the auditors. So in that acceptance and in their acceptance of the fines, their failure to appeal against the fines and the actual wording of the fines and decision, it is clear that there was fault, culpable fault, and it's common ground for the early stages, irrecoverable, or fault which makes fines irrecoverable. That takes it away from the innocent Osman and the kind of cases that are referred to where there may be a defence of strict liability. So that defeats the challenge to the narrow rule. The third point, which is in my submission important, and Your Honour asked me about this at the beginning, and I tried to answer it, probably not very adequately. Let me try and take it a little bit further. Just pick up, if we may, the leading again at the reply. And that is at page 319, paragraph 92. We see they don't seek to recover the full quantifier, the estimated delta between the fine actually imposed and those which would have been imposed. And then if you are kind enough to look at the page 254. Where they try and identify what they're looking for at C. The difference in fines imposed by the DFSA and those which would have been imposed have been estimated by taking the total fines imposed, subtracting fines which is estimated the DFSA would have imposed. Such calculation, assuming the DFSA would adopt the same methodology for determining the appropriate fine that was utilised in the respective decision notice. Now, the
So am I right in thinking that claim is brought on the hypothesis that by the 30th of September 2013, the auditors should have discovered the misconduct? Is that the proposition that you draw from this?
That seems to be what is being said, but the problem of the analysis is that how is this going to be done? Expert evidence I think it's how are we going to investigate this and decide and assume what the fine would be. So you have to take a hypothetical alternative fine and say that part of the misconduct which followed can be recovered because the auditors were negligent. And that part of the misconduct which led to the fines would not have been would not have happened because they would have been prevented. But it's still misconduct. And if the company accepts that it is liable for the fines caused by the pre-2013 audit company, it cannot say that it bears no responsibility for the post-2013 conduct. Now, I think I've covered in writing the causation issue. The attribution issue isn't relevant because the company was imposed, the fines were imposed on the companies personally. Indeed, the notices expressly state they're sanctions imposed on the company alone. So it's not, we don't need attribution for that. So it should be struck out. I just want to say very briefly the scope of duty and the argument, first of all, is not within the auditor's scope of duty. Secondly, that
sorry,
yeah.
Mr. Fenwick, just before you leave attribution, just see if I've got this. Your basic proposition is that attribution only arises in the sense that, in a narrow sense, in that where you're dealing with a narrow case, that is a narrow case for recovery of the penalty itself, then the only circumstance in which the maxim does not apply is a circumstance in which the offence is one of strict liability and it is established that the party convicted was not culpable or guilty of negligence in any way. Is that's your, have I got that right? That's your fundamental proposition?
Yes, but the party itself, including those who act for the company, the officers and directors, it's got to be purely a separate third party, like an auditor, like the insurance broker. If the person in ASCII had no reason to suspect that they were being supplied with liquor containing methylated spirits, and had been guilty of supplying it, and it was strict liability, then that would be the case. But what you can't do is to say, although the company is liable because the company is liable for its servants, that should not be attributed to it for the purpose of a claim against the auditors. Now, I accept that that is arguable depending on the evaluation of Lord Toulson's three-stage test. When you're dealing with other losses outside the narrow rule, but there's no space within the narrow rule for that question of attribution, and no authority to suggest that it should be. And that would bring you into direct conflict between the public policy considerations for imposing the fines on the companies and the companies alone. Because in every case, you would then start having it said, well, yes, the company did do all these things, but it only did it because it had one director who was dishonest, and that shouldn't be attributed to us for the purpose of the fine. If the fine is imposed on the company then the fine is imposed on the company and falls within the rule. So yes, you have, I think correctly, probably more succinctly than I could have done, identified that proposition. So I'm just going to mention very briefly scope of duty and within the scope. It's really both two sides of the same coin. It is not the duty of the auditor to prevent a company or an individual from committing a regulatory offence. It is the duty of the auditor to advise on what it finds and any shortcomings and errors in the accounts that it finds or should draw to the attention of them. But it's not, and therefore any losses which flow properly and within the rules of causation, proximity from that negligent conduct can, except where extirpi causa, one-man company type Mirza and Patel situations arise, be recovered from the auditor. But fines are in a different class because they're imposed by the authority for a public purpose. The fines are not caused by the breach of the auditor's duty. They're simply not prevented by it. And the scope of duty has the same thing. So although my learned friend spends a little bit of time on it, they really are all different ways of looking at this same basic point. The company is responsible, like any other claimant, for fines imposed on it for its own wrongful conduct, and they cannot be recovered. Now, I want to go back to the beginning just to urge upon you the importance of the court deciding this as an issue of law at an early stage. Because it is a question of law as we formulate it, it doesn't depend on anything other than the existence of fines for which the company accepts that it was responsible. So I've just identified. That falls within the narrow rule. If the narrow rule is not to be disapplied, and Your Honour has no basis on which to disapply it, now is the time to decide it, so that the case can proceed without it. Now, I don't know if the effort to try and separate the so-called recoverable fines from the so-called irrecoverable fines is going to include a separate and additional attempt by the claimant to introduce evidence. We won't, because we say it's all covered, and that has been and will be our case at trial. But if there is a clear legal rule which bars the claim, then it is the duty of the court to determine it when asked to do so at an early stage. And very often, in a case like this, a court will say, well, look, can we get that bit out of the way? Now, if it was only worth $5, I can understand the court will say, why are we going to spend a day of argument when it's only worth $5? It's not going to make much difference at the end of the day. But when the claim, I mean, they say their claim is worth 600 million. It may well come down to a lot less than that when proper rules of causation are applied. These fines are unitary. They're claiming 200 and whatever it is, 40 million, over a third
90,
of their headline claim.
290, I think.
I'm sorry?
But it's 240. That's right, after the deduction. Yes, that's right.
After deduction. But you know, they're going to say that they may change that. That's a preliminary estimate. We may have some expert evidence saying that it's more or less. So it's between a third and a half. Now, this court will be aware, and I don't say this in anything other than a general sense. The vast majority of audit claims will tend to resolve themselves because the parties will see whether there's fault on one side or on the other, and will assess carefully the legal risks involved and the factual risks involved and all the other risks and costs. If you have a claim which is inflated by 240 or 300 million, which should not be there, to half the claim, then that in itself is a barrier to the sensible resolution claim. It may not settle. The parties may well be divided. The claimant may not decide to abandon its claim. We may decide not to abandon our defence. There may be no compromise in the middle. But given that this is a clear legal point, and given that it has so much impact, it's a point which Your Honour should decide on this application. Unless there's anything I haven't covered, that's all I wanted to say, and I hope I haven't taken too long in doing so.
No, that's Mr. Fenwick. There's just one question I want to ask, and that is, your argument's been presented on the assumption, or the implicit assumption, that the case is governed by the common law of England and Wales, but it's not. So what do you say? What do you say is the applicable law, and what are the applicable legal principles? If it's not, how do the cases to which you've referred come to govern the outcome of this case?
They come to govern the outcome of this case because of there are. I think I can put this in 3 ways. Give me 1 moment. We actually look at it, as you'll see at page 8 onwards of our skeleton, paragraph 30. So it doesn't matter whether it's DIFC law or Dubai law, because whichever court applies, it's always subject to public policy in the DIFC, and I've shown you Article 6 already. So public policy emerges. Law of the forum governs matters of public policy, and nobody contends that on this issue public policy differs in the DIFC from public policy in the UAE.
But why is public policy of the UAE equivalent to the public policy of England and Wales?
Well, I'm looking at the DIFC, and we've shown you paragraph 32. The defence is acknowledged in some statutes, so there are statutes which acknowledge it. Article 6 specifically engages public policy and public morals.
But it doesn't tell me what is the public policy. So why would I assume that the public policy is that specified in England and Wales?
Well, this is the rule on illegality, as Your Honour knows, is applied in multiple jurisdictions, many of them including some of the Australian jurisdictions.
But that's not the UAE or the DIFC. So why would I assume that the public policy of the DIFC is the same as the public policy of England and Wales?
Because the public policy of England and Wales formulates a more general rule of wide application that public policy will not permit there to be a conflict between the criminal and regulatory decisions and the civil law. And illegality was accepted by Justice Al-Muhari in Vejibar. The existence of that in some statutes. The public policy is always general, and there has to be a public policy. It's not suggested by my learned friend that the DIFC has a public policy which permits there to be discord and inconsistency between criminal and civil jurisdictions. And we say that public policy, and we're using England and Wales because of the authorities which are there, which we say are of general application and can usefully be followed. I don't say they should be followed because English law and English common law applies. I say they should be followed because they are the principles of public policy which should govern the law of the UAE. And to turn Your Honour's question on its head, how can it be asserted that public morals and public policy are not there to uphold the principle that a fine imposed should not be recovered by a third party, so that the wrongful person is, if you like, absolved from the liability which the regulators decided to put on them. When you read those decisions are public, effectively, encapsulation of public policy as to why you impose a fine on the entity and on the entity alone. And that is all those things like discouragement, example, and so on. They're all set out in those. And we've identified them in our skeleton. So it's not a matter of that you must do it because England and Wales says so. England and Wales provides very good examples of how the narrow rule will apply. And no one is at the moment suggesting, and we've had a look at some of the Australian, New Zealand and other cases, to say that there is any other public policy other than the one which we've identified, that you should not have a conflict between the criminal law and civil and tortious and contract law.
If it's common ground that the public policy of the DIFC and the public policy of the UAE are the same on this topic, don't I need to know what the public policy of the UAE is?
No, because we're saying that the UAE, we're not suggesting the UAE is different to the DIFC.
Oh, I see. All right. All right.
And
you do get some support from Article 56 of the law of DIFC law of obligations, I think.
I do, and I also get some support from UNCITRAL, despite Learned Friends' reference to it, and I will deal with that very shortly in response. But it doesn't give him the safe haven contract, and if it did, we'd have this curious finding that in the law of obligations, you have a public policy, but you don't get it in contract law. So the two, which very often go, and these claims are brought in contracts and in breach of the law of obligations, you would have completely different competing public policies, which is bluntly nonsense. But I'll come back on that because I want to see the way he puts it before I answer it. Is that anything? I'm just going to try and do a little bit of magic to see whether yes. So we don't suggest, and nor do the claimants suggest, that in the UAE it's permissible to recover a fine as damages. So I was really covering it to make sure that the fact that we contend for UAE law doesn't give a different
the other way around. Yes, all right. Yeah. Thank you. All right.
Unless I can assist you further, I shall.
Thank you very much, Mr. Fenwick. Mr. Hubble, should we take a break now? I think we've got potentially up to another hour or so to go, or longer. Do you have any? I'm just worried about the transcriber, though. We've been going for an hour and a quarter or so since. No, we've been going for almost 2 hours since the last break. I wonder if we should take a break now for the benefit of the transcriber. Would that be convenient?
That'd be very convenient, Your Honour.
Yes. And do you have any idea how much longer you might, how long you might need, Mr. Hubble?
Your Honour, I suspect I would be in the region of 2.5 hours.
All right. Well, it looks like we're going over to tomorrow then, by the looks of things, because I can sit on, but I think I'm just worried about the transcriber. That's all. It's all right. Well, why don't we break for 10 minutes?
Certainly.
We'll break for 10. So why don't we resume at it's 7 minutes? Why don't we resume at 20 past the hour? that convenient?
I'm told that the transcriber has asked for 45 minutes for lunch, which I don't know how that fits with your sitting time, but I should at least pass it on as a request.
Yes, all right. Well, that would, well, if the, I mean, gentlemen, how late are you prepared to go? I mean, it's pretty early in the morning in the London. If the transcriber is prepared to go into the afternoon, we could break for 45. It's getting a bit late where I am, but if there's a chance we could finish it today, we could sit on. If what do you think, Mr. Hubbard? You'd rather finish it today?
Your Honour, yes, but there is quite a lot to get through.
Yes, right.
We are ships in the night on some issues, so there's quite a lot that I have to explain from a different starting point.
All right. Well,
so maybe we have to see how we go, Your Honour.
Yes. All right. Well, if the transcriber wants 45 minutes for lunch, that means we'll be resuming at 11 p.m. my time, which I'm not sure that I'll be giving your argument the full attention that it deserves.
No, I'm very wary, Your Honour. You'll appreciate this is a very important issue.
I do understand.
A lot of money turning on it.
Yes. Well, why don't I wonder if
I'm sorry, Your Honour. We've been offered a 30-minute compromise by the transcribers.
Right. Why don't we adjourn for 30 minutes? So resume at 20 minutes to the hour, and then see how we go then. All right.
Your Honour, yes, and it may be, for instance, that I may be able to deal with some matters in, say, an hour, and then I can come back tomorrow morning. By the sound of it, we're going to be coming back tomorrow for a reply anyway. I can come back tomorrow morning.
I think that's probably right. And as I say, I don't want to do your argument any disservice by falling asleep while it's being presented, Mr. Hubble. I'm sure I never would. I'm sure no judge ever has.
Let's avoid the risk, Your Honour.
All right, we'll adjourn for 30 minutes then and resume at 20 to the hour. Thank you.
I'm grateful.
When you're ready, Mr. Hubble.
Thank you, Your Honour. Your Honour, the application notice, it's just worth reminding ourselves what we're actually dealing with. The application notice is at page 446, and it's to strike out paragraphs 43.2, 59 and 70.2.3 by way of strikeout from the particular claim. And I'll be taking you to the particulars of claim in a short while on the basis that they disclose no reasonable cause of action. And then immediate judgment per RDC Rule 24 of claims for recovery of fines imposed upon the claimants by the DFSA. And as advanced, as Your Honour knows, the application has two limbs. First, it's suggested that the claimant's claim for damages in respect of the delta for the DFSA fines is barred by the doctrine of illegality. And second, it's suggested that the loss claimed in respect to the DFSA fines is outside the scope of the duty owed by the auditor. And the primary focus of the application appears to be the illegality limb. The scope of duty limb was advanced briefly by my learned friend and was put on the basis that it's the same two sides of the same coin, although for reasons I'll come on to, that's certainly not accepted. In terms of the structure of my submissions, I propose first to make some preliminary observations, then second to consider the factual background and in particular certain of the DFSA notices, third to turn to the illegality limb of the strikeout application, and then fourth and finally to turn to the scope of duty limb. If I deal first of all, Your Honour, with some preliminary observations, a statement of the obvious first, but I submit nonetheless a useful one. Just standing back, this doesn't appear as the sort of application that really this court should be dealing with on a short interim hearing. Before we get into the meat of the application, you can see from the skeleton arguments that there are numerous issues raised and they bristle with complexity. The bundle is nearly 5,000 pages long, and by my reckoning, there are 48 authorities cited, and that ignores statutes, practitioners' guides, and academic articles. So second, Your Honour, as a preliminary observation, the court will know that the hurdles facing the defendants on an application such as this one are high ones. We set out some principles to be applied in applications of this sort at paragraphs 12 to 15 of our skeleton argument at page 1775. And if I deal first of all with the strikeout limb per RDC 4.16 and the test and what is needed, first one must proceed on the basis that the pleaded facts are true, as we make the point at subparagraph A. And secondly, the court, of course, should only strike out where the claim discloses no valid cause of action as a matter of law. And I highlight subparagraphs C and D. The court should only strike out a particular cause of action at this interim stage in circumstances where the court is certain that that claim is not going to succeed. And we've provided the quote from Lord Brown Wilkinson in Barrett and Enfield Borough Council, that where you're in a developing area of law, extreme care should be taken before striking out. And difficult issues in relation to developing areas of the law should be dealt with in general at trial, after the facts have been found and after the court had the benefit of full submissions on the law. And picking up on an observation made by Your Honour earlier on today, if you look at our subparagraph 13D and the general approach to striking out, and the observation of Lord Templeman and Williams and Humbert Limited, can I ask you to go, please, to the extract there, which is at page 2114. And if you go to the foot of the page to letter H, so the foot of 2114, my lords, if an application to strike out involves a prolonged and serious argument, the judge should, as a general rule, decline to proceed with the argument unless he not only harbours doubts about the soundness of the pleading, but in addition is satisfied that striking out will obviate the necessity for a trial or will substantially reduce the burden of preparing for trial or the burden of the trial itself. And this is absolutely a case where the striking out isn't going to obviate the necessity for a trial, nor will it substantially reduce the burden of preparing for trial or the burden of the trial itself. Indeed, certain of my learned friend submissions seem to suggest that illegality defences are going to be pursued in respect of wider claims for loss in any event. So the DFSA investigations and notices and illegality issues, by the sound of it, are all going to be in play at the trial anyway. And those observations that we identify in subparagraphs 13C and D are all the more applicable when one considers that we're not actually in a court in England and Wales, we're in a court in the DIFC. And so it will be for the DIFC to decide and the court to decide how and when to apply these public policy issues. So the court should be even more wary of proceeding on the basis of a close passing of English authorities, many of which do not walk in line, when actually this is going to be a trial in the DIFC in any event. So far as the test for immediate judgment is concerned, no doubt Your Honour will be very familiar with the test. But if I can just draw attention to certain of the principles, and we find that in the judgment of Justice Giles and GFH Capital at page 3359. The principles will be familiar to you, Your Honour, but firstly, the court must consider whether here it's the claimant's case has a realistic prospect of success, i.e. some degree of conviction. And the claimants submit for their part that the case has a formidable prospect of success. The court must not conduct a mini trial. The object of the rule is to deal with cases that are not fit for trial. And here we say that however the defendants attempt to present things, they are in reality inviting the court to conduct a mini trial. That is an expression that encompasses not just disputed issues of fact, but also complicated issues of law, and also complicated issues as to the application of public policy factors. The court should not be drawn into resolving conflicts of fact. The claimants say that no such issues arise, but that's only on their very prescriptive approach to the narrow rule and their contention that it continues to apply unabated. The defendant simply seem to suggest that the sort of considerations that Lord Toulson dealt with and Patel and Mercer just simply don't apply. But as soon as you're into, as I submit the court should be, into considering wider public policy factors, that's simply not appropriate to deal with at this sort of interim stage.
Well, Mr. Howell, it's very early days yet. I haven't heard you, but it seems to me that is the critical question. Because if Mr. Fenwick is right, you don't get to those issues on the narrow. If your claim is properly classified as one with the narrow rule, and you don't, and those issues become irrelevant, then the case, I think, your case gets more difficult, significantly more difficult. Well, having said that, on the other hand, if we are into the sorts of considerations identified by Lord Toulson and Patel, then I think your argument that this is not apt for summary determination becomes a strong one.
Well, I'm grateful for that helpful indication, Your Honour. And I'll come on to deal with it. We say that this absolutely is not a straightforward application of the narrow rule for a whole variety of reasons, including what the correct position as a matter of law is in England and Wales, and the fact that we're dealing with claimants, not individuals. We're dealing with a variety of offences, some strict liability, some not, and we're dealing with regulatory fines rather than homicide cases. So there's a whole load of distinguishing features, I say we absolutely are in the territory of conducting the sort of review that Lord Toulson identified in Patel and Mercer. Even if I'm wrong about that, we're absolutely in the territory where I've got a argument with real conviction that we're in that territory, which is enough for present purposes. And that leads, Your Honour, into my third point, which is the general points about the limbs that one applies on these applications are reinforced by this type of the specific application that's before you today. That the primary limb of the defendant's application is the illegality doctrine, and it's important to note that that's a doctrine, not a defence. It's not as it were, a defence that arises on the merits between the claimants and the defendants. It's purely based on public policy. And so the primary limb of the strikeout application isn't based on the contention that the claimants do not have a valid cause of action. Rather, it's based on a contention that there may be a valid cause of action, but there should be a bar imposed by the court on that valid claim on public policy grounds. So that's what the court is being asked to determine on this application. So, in other words, the defendants in the courts conclude that the illegality doctrine should bar the claimant's otherwise valid claim and find it unanswerable. And that's on the basis that nothing can happen between now and the end of trial that can change that position. And that's a very high hurdle. And as I'll come to show you in due course, there are a clutch of English authorities that warn against dealing with the illegality doctrine on a summary basis of this sort. including the decision of Mr. Justice Voss, as he then was in Griffin, and the recent decision of Mrs. Justice Collins Rice in Owen's Alley. And the position in my submission, Your Honour, is similar in relation to the scope of duty application. First of all, it's very difficult to see how that application could possibly succeed. The claimant's claim for loss arising from the DFSA fines has a formidable prospect of success. The fines arise from matters which the auditors had an obligation to investigate and report to the company's members. And it's really as simple as that. But in any event, the interaction between auditors' duties and negligence and adverse regulatory implications for audit entities is plainly a developing area of DIFC law where the position will be best addressed at trial. So, in summary, first, strikeouts and immediate judgment applications rightly impose high hurdles because the court is being invited to shut out a claimant on an interim basis without the hearing of their claim at a full trial. And second, the nature of the defendant's applications are particularly unsuited and inappropriate for summary determination. So, Your Honour, those are my preliminary observations. If I turn to part 2 of my submissions, which is the factual background and the DFSA fines and the pleading, Your Honour will have this point, but for present purposes, there are 4 DFSA decision notices that are particularly relevant. First, that against AIML for $299.3 million. I'll give you the reference and I'll go to certain of the notices in a moment, which is at page 1010. Second, that against ACL for $15.3 million at page 951. Third, that against KPMG LLP, which is the third defendant, for $1.5 million at page 744. And fourth, that against the engagement partner from KPMG LLP, Mr. Navalka, for $500,000, which is at page 813. Now, the defendants have taken you to the decision notices for AIML and ACL in opening. At this stage, by way of introduction, can I take you to and introduce the table to our skeleton arguments, which you'll find at 1798. Because the court may find it a helpful aid memoir. And let me just explain that table to you. There were 2 limbs to the fine imposed on AIML, and there were 6 limbs to the fine imposed on ACL. And what we have done in table 1 is we have broken down so that you actually have the statutory basis for the fine that's imposed set out. And then we've identified whether it's a strict liability offence or not. And the position, as I understand it, is accepted by my learned friend Mr. Fenwick that some of these offences are strict liability, some of them aren't. That was his position in submissions today. So that's the purpose of the third column, strict liability, yes or no. And then the fourth column becomes particularly pertinent when one comes on to consider the question of Safeway in the Court of Appeal and the question of whether there is some special attribution rule here, whether the breach was only capable of being committed by a corporate entity or whether it could have been committed by individuals, that being the distinguishing feature identified by Lord Sumption at least. And then finally, the divisible elements of the fine. When we come on in a little while to look at the authority of Safeway, what you don't find in any of these statutes or rules that have been extracted in this table is any wording akin to that of section 36.3 of the Competition Act, which was the basis of the decision in Safeway. So that's hopefully a helpful aid memoir.
Can you just walk me through it, if you would, Mr. Hubble. I'm looking at the first item on item provision 2, Article 41B of the regulatory law. Must not, from the DIFC engage in conduct in connection with the financial product or financial service that is misleading or deceptive or likely to mislead or deceive, fraudulent or dishonest. And you've said, yes, according to your table, that's an offence of strict liability. Now, clearly that's not the case in relation to fraudulent or dishonesty, is it?
Well, it depends on what the contravention would be for. If it was likely to mislead or deceive,
I'll come back to that. Fraudulent or dishonest, they're not strict liability offences, are they?
Well, not insofar as they involve mens rea, no. So there's an element of that case.
But then misleading, so you're saying it's misleading or deceptive or likely to mislead or deceive because it can be committed without knowledge of the misleading or deceptive nature of it. So there's no mens rea required. So that's what you mean by strict liability, is no mens rea.
Exactly.
Yes, all right.
So if you went back,
we've got to be careful with this table, obviously, because I would distinguish between A, B, and C there. I would say I'd be inclined to say no in relation to B or C, but possibly yes in relation to A.
Your Honour, that's probably a fair criticism of the table. It could have been more detailed and more broken down in that way. But the aim of the table was to show, which I think is common ground, is that some of the offences are strict liability, some of them aren't.
Yes.
So if we then move to the decision notices, my learned friend has taken you to the decision notices for AIML and ACL. But an unusual feature of this case, and it becomes relevant in a couple of submissions I'm going to make in due course, is that there were decision notices imposed on AIML and ACL, but there were also decision notices imposed on KPMG LLP, the third defendant and the audit engagement partner. And both the claimants and the defendants rely on that in the context of this application for purposes. But it's plainly a relevant and distinguishing feature between this case and others that the court has looked at. And so can I ask you to look briefly at the decision notice in relation to KPMG LLP, which is to be found at page 744. You'll see that from paragraph 1 that a fine of $1.5 million was imposed pursuant to Article 92A of the regulatory law. Over at 745, you'll see a summary of the reasons, commencing at paragraph 3.1. And in the period from the 9th of February 2012 to the 30th of October 2017, KPMG failed to comply with obligations as a registered auditor in failing to carry out adequate audit procedures to enable it to give an opinion on whether financial statements were prepared per the FRSS and represented a true and fair view of the conditions and state of the affairs of the firm, conduct the audit of an authorised firm's financial statements and conduct its review of the firm's PIB returns. And those are then developed at 3.2 and 3.3, where at 3.3 it's identified that there was a failure to identify that ACL's financial statements didn't present a true and fair representation of ACL's financial position and the level of ongoing financial dependency on AIML, that ACL employed window dressing transactions at year end, there was doubt as to the preparation of financial statements on a going concern basis, and ACL repeatedly acted in breach of DFSA capital requirements. Can I next take you to page 768 and paragraph 5.18 in the decision notice? So page 768, paragraph 5.18. And there it's observed in the decision notice that it's a recurrent theme of KPMG's representations that it was the victim of a sophisticated fraud on the part of the management of ACLD. DFSA does not consider that the undoubted fraud in the Abraaj Group was sophisticated. Most obviously, the window dressing carried out in relation to the ACLD was straightforward and should have been apparent on even a cursory review of its bank statements around the date in question. The DFSA has seen no evidence of the forgery of bank statements or other documents, say possibly in respect of bank statements that include the ACLD's bank account. So that was the finding made by the DFSA. And then the contraventions are dealt with at 780. And they relate to contraventions of Article 101 in relation to auditor's duty, that the third defendant failed to carry out such investigations as would enable it to form an opinion as to whether ACL's financial statements represented a true and fair view. At 2, General Rule 8.9.1b, they failed to comply with the ISA's quality control and codes of ethics. And at Rule 6.2.1, failed to conduct audits and assurance reviews in accordance with relevant ISAs and ISAs. And I'm going to take you, please, over the page to 781 and sanctions. Because those they will have an obvious echo when later on, in due course, when I deal with the question of public policy considerations and the three-stage test under Patel and Mirza. At 7.2, the DFSA objective is to prevent conduct that damages the reputation of the DIFC, and there's a deterrent effect of deterring KPMG and others from committing further or similar contraventions. And the seriousness of the contraventions is noted, including the impact on the reputation of the audit profession and DIFC. And then the seriousness of the contravention at 782, identified at 1, the role of a registered auditor of ensuring authorised firms' financial statements comply with FIS and give a true and fair view is integral to enhancing investor confidence and is paramount as the last line of defence. As such, KPMG's failings were damaging to investor confidence, the reputation of the DIFC, the reputation of auditors in the DIFC, and contributed to a loss of confidence in the DIFC markets, most notably private equity. So, as I say, I'll come back to it, but I draw that to your attention because it's not obviously relevant background when one comes on to public policy considerations in due course. The fine in relation to Mr. Navalka is at page 813. I don't think I need to take you through it, but it is to very similar effect. If I take you to page 814, you'll see the summary of reasons, and essentially this decision notice proceeded on the basis that Mr. Navalka was knowingly concerned in KPMG LLP's breaches as he had overall responsibility for the conduct of the audits and the reviews of ACL performed by the LLP. And he was the audit partner for the various entities. And the decision notice then follows a very similar format in terms of the findings, the objectives of the DFSA, and the seriousness of the conduct. So that's the other decision notices that are particularly pertinent that you weren't taken to. It's right to identify that no fine has been issued by the DFSA against KPMG LG, the first defendant, in relation to the audits of AIML, and that presumably reflects the fact that KPMG LG, the first defendant, is not registered and authorised by the DFSA, whereas KPMG LLP is. So you have a fine by the DFSA against ACLD, and then a fine against its auditors, KPMG LLP and the audit partner. We have a fine on AIML, but not a fine on the auditors, the first defendant, the auditors of AIML, because they weren't registered in the DFSA. So that's the decision notices. Can I turn then to the claim advanced in these proceedings? So Your Honour has the shape of the claim. The claim advanced against the defendants is one for audit negligence. And in simple terms, the defendants were the auditor of the claimants. The defendants failed to conduct proper audits, and they failed to identify blatant window dressing at year ends and misappropriations by senior management, that AIML was carrying on financial services activities when unauthorised, and that ACL was not in fact complying with capital requirements. So those are the allegations in essence. And that had the defendants conducted proper audits from financial year 13 onwards, then they would have reported to the members of the companies on the financial irregularities, the misappropriations and the wrongful conduct of certain senior management. And they wouldn't have given clean opinions on the financial statements and the PIB returns. And in the absence of corrected or management agreeing to correct the financial statements, the defendants would then have had to qualify their audit opinions or resigned. And then had the defendants complied with their obligations, then those charged with the governance of the claimants would have caused the financial irregularities and wrongful conduct to stop. They would have replaced the culpable senior management and regularised the basis on which the claimants traded. And then either there would have been a solvent causation scenario where the business, there was a turnaround strategy, or an insolvent one. But in either scenario, the additional misappropriations and financial irregularities from the appropriate trigger date, the discovery date, would have been avoided. And the proportion of the DFSA fines imposed by reference to events after that trigger date would have been avoided. Your Honour will have seen that there's a very substantial overlap between the allegations of breach advanced in the particulars of claim and the findings of the DFSA notices against KPMG LLP. Can I take Your Honour to the pleading to see how the pleading pleads out the position in relation to breaches and the fines, which is relevant partly to understanding how the case is put. It's relevant to the fact that there's a strikeout application in relation to particular specific paragraphs, and actually it's relevant to the scope of duty limb of the application that's advanced. So for that purpose, can I ask you please to turn to page 24.
Yes.
And to paragraph 15. And you'll see that in the centre of the page, in paragraph 15, there's the plea that the contractual and tortious obligations and duties referred to in paragraphs 1, 11, 13 and 4 above require the defendants to comply with the ICEs, and in particular the following duties. 15.1 pleads ISA 200 and the need for high levels of assurance that the financial statements as a whole are free from material misstatements. But can I draw your attention to PC 15.7 on page 25, at the foot of page 25. Again, this is a pleading of breaches, pleading of duties by reference to the applicable ISAs, to obtain an understanding of the entity being audited, its nature and environment, including obtaining a general understanding of the legal and regulatory framework applicable to the entity being audited and the industry or sector in which the entity operates, and how the entity is complying with that framework, the way the entity is structured and how it's financed, and the relevant industry, regulatory and other external factors. So it's an important feature. My own friend in his skeleton argument concentrates only on ISA 200 and ISA 240, but ISA 250 deals expressly with law and regulation and the auditor's obligations in relation to that. And then at 15.8 over the page, at page 26, the obligation on the auditor to design and perform audit procedures whose nature, timing, and extent are responsive to the assessed risks of misstatement due to fraud. And then at 15.10, page 27, the obligation to report. My learned friend speaks in his skeleton argument, spoken on a number of occasions about the case being framed as an obligation to prevent. It's not. It's an obligation to report on a timely basis to those charged with governance various matters, material misstatements, extent to which the financial statements are affected by unusual transactions, and at 15.10.5, any identified or suspected non-compliance with prevailing laws and regulations, save where clearly inconsequential. And then 15.11 is the duty to qualify or modify accounts unless they were corrected. So there are the pleadings of duties, and it's important to note that the duties extend, as I say, to ISA 260 and law and regulation, in addition to ISA 200 on irregularities in financial statements and ISA 240 in relation to the obligation to identify and detect fraud. So those pleas of duties flow through into the breaches, and if I can highlight, please, page 46 and paragraph 43.2. So this, you'll see the heading defendants' breaches of duty. In breach of their duty set out at paragraphs and so on above, the defendants fail to exercise a reasonable care and skill in the conduct of the audits. Any competent and auditor exercising reasonable care and skill would have identified and reported the irregularities. 43.2 identified and reported the fact that AIML was carrying out financial services activities in the DIFC without authorization, aided by ACLD. No such report was made. Identified and reported irregularities in respect to the PIB returns. Now, 43.2 is one of the paragraphs that's subject to an express application to strike out. And we say simply misconceived. You can see the breaches that have been, the duties that have been pleaded, and then the duty follows on from, the breach follows on from the duties that have been pleaded, which themselves reflect the ISAs. There are other relevant pleas of breach at paragraph 54 in relation to AIML. So you'll see the heading breaches relating to AIML's unauthorized financial services activities. These, of course, all being matters that the relevant conduct gave rise to the fines. So here are the breaches pleaded by reference to matters that had the effect of resulting in the fine continuing. So, and the way the matter is put, as we see at 54, and it's repeated in a few other places, KPMG LG should have identified the fact that AIML was carrying out financial services activities in the DIFC without the required authorization. It would alternatively should then have concluded that this matter resulted in material misstatements in the AIML group's financial statements in the absence of appropriate accounting treatment, such as the provision for the resulting fine or disclosure of a contingent liability. And KPMG would have sought to understand, should have sought to understand the relevant regulatory framework. And we say there's nothing remotely surprising about that plea, and nor is there anything surprising about the fact that it's a plea when one comes to loss and damage for the fact that the fines could have been brought to an end earlier. That's exactly the same as the position in relation to misappropriations with management, for instance. If you go to 59 on page 58 has been identified as a paragraph that should be struck out. As I understand it, the whole of paragraph 59. This is breaches relating to ACLD's unauthorized financial services activities. And it commences, KPMG LLP should have identified the fact that Mr. Nakvian and or other executive managers were using ACLD to assist AIML in carrying out financial services activities in the DIFSA without the required authorization, and that it flows through into the financial statements because there should have been a provision for the resulting fine or disclosure of the contingent liability. And one sees the same ISA 250 relied upon. So again, on the face of it, perfectly valid allegation of breach based on the duty that's been pleaded. At paragraph 60 on page 59 under the heading the defendant's failure to report, you see the obligation to report the various irregularities set out above and to modify or qualify the opinion. Paragraph 64 on page 62 is part of the plea on causation, which effectively can be summarised for present purposes as, had there been a proper report by the auditors, those charged with governance, and in particular the non-executive directors, would have effected change and stopped the irregularities from continuing. And then that flows through to the final paragraph, which is expressly part of the strikeout application, which is on page 65, which is the plea for loss and damage in respect of the fine. So that's 70.23. Liability for DFSA fines that would not have been incurred but for the defendant's breaches of duty provisionally estimated at 242.1 million, but which will be further particularised in factual and or expert evidence in due course. And as per your exchange with my learned friend Mr. Fenwick, that's the amount of the fine that postdates the discovery date when one applies the principles based on which the fines were calculated by the DFSA. So that's something of a canter through the particulars of claim, but the essential points I invite the court to draw from it is one has a clear pleading of the relevant duties under the ISAs, a clear pleading of breach of those specific duties and the impact it would have had on the financial statements, and causation, and then the claim for the fine. That element of the fine which would have been avoided had the auditors done their job properly. So that's the thrust of the claim and the thrust of the pleaded claim that's before you, Your Honour. So with that introduction, if I turn, if I may please, to the third aspect of my submissions, or this is going to be a significantly longer section, which is the illegality limb.
Well, we're going to come back, Mr. Hubble. I'll leave it to you to choose an appropriate time. We can go for a little longer, but we're going to come back tomorrow. So whenever you think is a convenient time to adjourn, we'll adjourn. Do you want to take a start on illegality and then come back? Is there a convenient point to break?
Your Honour, what I may do is is deal with an introductory section so that you have the shape of what my submissions on illegality are going to be, and then we might perhaps break them.
Yes, if that's all right. Thank you. Thank you.
So in relation to the illegality limb, Your Honour, the defendants, as they must, try to present the illegality limb of the strikeout application as being simple and straightforward. And the contentions upon which their analysis is built run, as I understand it, as follows. First, it's said that there is a narrow rule derived from Lord Hoffman in Gray and Thames Trains. Second, it said that the narrow rule applies to regulatory sanctions. Third, it said that the narrow rule survives the overhaul of the law on illegality undertaken by the Supreme Court of England and Wales in Patel and Mirza. Fourth, it said that the narrow rule bars the claimant's claim in respect to the DFSA fines. And fifth, it said that all this applies automatically to the courts in the DIFC as well. In relatively short order, we say that analysis is in part simply wrong, and in part it's unduly simplistic. And our response breaks down into the following 8 points, which I'll set out for you now, Your Honour, and develop tomorrow. The first point is that it's only correct to say in our submission as a matter of English law that there was a narrow rule identified by Lord Hoffman in Gray and Thames Trains to the effect that you cannot recover for damage which flows from a fine or other lawful punishment imposed on you in consequence of your own unlawful act. That's the narrow rule as identified in paragraph 32 of Gray and Thames Trains. But that narrow rule has itself been narrowed further and in effect largely overtaken by Patel and Mirza. And fundamentally, this area of the law in England and Wales has been heavily reviewed and overhauled by the Supreme Court in Patel and Mirza. And it's to that three-stage test laid down by Lord Toulson in Patel that this court ought now to look. And the defendants are simply incorrect to suggest that the narrow rule as a whole has somehow been declared as Patel compliant, such that Lord Hoffman's narrow rule continues to apply to any criminal fine. All that was found in Henderson and Dorset NHS Trust, the judgment of Lord Hamlin that my learned friend Mr. Fenwick took you to, was that pre-Patel cases continued to be of precedential value in respect of their outcomes, and that the decision, i.e. the outcome in Gray, should continue to apply in that particular type of case. So Gray should apply and be followed in comparable cases. That was the decision of Lord Hamlin. That simply means in other homicide cases, Gray, Clunis, Henderson. In the present claim, namely a regulatory fine and a claim against the auditors who failed to identify and report on the circumstances giving rise to that fine, it is a world away from that run of cases. So my second submission, and second and relatedly, the fact that, as I understand it, the defendants invoke that it's been suggested that the illegality doctrine and the narrow rule can apply to quasi-criminal fines. It is nothing to the point. It doesn't mean that the narrow rule continues to apply, let alone that it automatically extends to any regulatory fine. Third, our submission is that unlike the claimant in Gray, the claimants here are not individuals, they are companies. And thus the court has to grapple with attribution and whether or not the DFSA fines can be said to be personal to the claimants, such that the law does not permit them to recover losses attributable thereto from negligent servants or agents. And I'm sure Your Honour has this point well in mind, but it's worth making an important distinction clear from the outset, that there is a distinction between the position as between the claimant and here the regulator, and whether the claimant has to take responsibility pursuant to agency and vicarious liability as between itself and the regulator when it comes to a fine. That might very loosely be described as attribution, but that's agency and vicarious liability. And then there's another question, which is as between the entity that has been fined and its negligent director, its negligent auditor or other advisor, is the wrongful conduct of certain senior management attributed to the claimant entity that's been fined such that it can't bring the claim against the third party advisor? They're two different points. And when we're talking about attribution, it's very important to remember we're talking about whether there is wrongful conduct that is attributed to the company for the purpose of and so as to prevent a claim by the company against that third party. And we simply say that that is not the position here. There is no attribution for that purpose. Now, the defendants, in effect, have to rely on Safeway and the Court of Appeal in England and Wales in support of their proposition that the regulatory fine on a company is personal to that company, and therefore the company is fixed with it and can't seek to lay off the loss against any other entity. But as I'll develop tomorrow, that decision is not of general application it's been confined by the Supreme Court in Bilter to its own facts and said not to be of general application, including by Lord Sumption, who, when still at the bar, was counsel for the appellants in Safeway. And the reasoning in Safeway has been doubted and in part expressly disagreed with by the Supreme Court in Bilter. Safeway is also subject to strong academic criticism, cited with approval, the academic criticism that is, cited with approval by Lords Hodge and Toulson in the case of Bilter, of Professor Watts, who's the general editor of Bousted and Reynolds on Agency, who you know, well, I'll come to show you tomorrow. There are a couple of paragraphs that are in the category of "I couldn't put it better myself" from Professor Watts in this issue. And so we submit that Safeway just can't be regarded as good law for this purpose in England and Wales, let alone in the DIFC. And indeed, a judge at first instance in England has recently declined to follow Safeway on an application for summary judgment in respect of a regulatory fine, which application was refused. That's the case of In Re Mobigo, which we'll look at tomorrow. Fourth, again, unlike in Gray, various of the contraventions here were breaches of strict liability offences. And even when the narrow rule was in force, there was an exception for strict liability offences. So quite separately from other matters in issue, you've got the complicating factor that some of the offences here were strict liability, some were not, and there's an investigation to be undertaken in relation to that. And in effect, what that becomes something of a subcategory in relation to attribution and what is or isn't required in relation to a subcategory of strict liability cases, a further complicating factor. Fifth, we submit that when the three-stage Patel process is undertaken, it can be seen that there are powerful arguments in favour of the claimant's claim proceeding. So we say you do have to undertake that three-stage process in England and Wales on the law. And on any view, there are arguments with real prospects of success in favour of the claim that can only be resolved at trial. There are public policy considerers positively in favour of the claim, including the protection of shareholders. Sixth, there is, in my submission, an irreconcilable contradiction at the heart of the defendant's application. The narrow rule was based on the consistency principle and the desire to avoid damage to the integrity of the legal system arising from inconsistent stances being adopted by the criminal courts and the civil courts. That's the narrow rule as explained by Lord Hoffman in Gray. Now, the defendants invoke this principle and they labour it for the purposes of this application on the basis of what's said to be the importance between the regulatory and civil law, which they say goes to support why the narrow rule applies and should be enforced. But the irony is that if there really was a risk to the integrity of the legal system from an inconsistency between the decision notices as a matter of regulatory law and these proceedings, then that would come not from the claimant's claim, but from the defendant's defence and counterclaim. The defendants run a defence on breach of duty that is entirely at odds with the decision notices against KPMG, LLP, and the audit partner. In other words, the defendants invite this court to make findings on breach and factual causation that are completely at odds with those decision notices. Indeed, their very defence to this claim presupposes inconsistent future decisions between this court and the defendant, the decision notices as against them. So the defendants, in my submission, can't have it both ways. These alleged public policy considerations cannot be so powerful the claimants are shut out from bringing a viable claim, whilst at the same time so insubstantial that it's proper for KPMG LLP as a registered auditor to run a defence and counterclaim which is flatly inconsistent with the decision notice against it. In fact, it's our claim against the defendants' auditors that is consistent with the decision notices against AIML and ACL. We don't dispute there was misconduct by a significant element of senior management of AIML and ACL. We simply submit that that doesn't prevent a claim against the auditors, including on grounds of attribution and other matters. Seventh, what all the above shows is that the illegality defence is plainly not suitable for summary determination, especially in the DIFC. The claimants have, putting matters at their lowest, a real prospect of success, and the claim in respect to the DFSA fines can only be fairly and properly determined at trial. Eighth, and finally, that there are compelling reasons why this claim in respect to the DFSA fine should go to trial anyway and should be considered as a matter of DIFC law. First, it will be my submission to be developed tomorrow that the illegality defence doesn't presently exist under DIFC contract law, and so cannot apply to the claim in contract. So that's on the authority of Hamid in the Court of Appeal of DIFC. And if that's right, even if this case was to succeed, the application to strike out the claim in contract would be proceeding to trial. And Article 8A of the application law, if it was to come in, would seem to reinstate the law of England and Wales as a backstop, so that it wouldn't amount to judicial legislation for it to be taken into account. But as I understand it, that's still a consultation paper at the moment. It hasn't come into force as yet.
No, that's right. And there are some differing views on whether it should come into effect. And the court has a view.
I can readily imagine. But for present purposes, the point is that it hasn't come into effect yet.
No.
No.
And it may never.
Well, exactly, Mo. It's a rather bespoke and extreme version of the sort of developing area of law, leave it for trial point. We don't quite know what law we have or don't have.
Well, I don't think it's a secret that the court's view is that there should be the court should be empowered to develop a common law of the DIFC, drawing upon whatever common law sources it thinks appropriate to the conditions and circumstances of the DIFC. But we'll wait and see whether His Royal Highness agrees with that.
But acknowledging that's a view only, albeit a very important one, but it's a view only. That militates absolutely in favour of my opposition to the application, because my learned friend Mr. Fenwick's application is based on treating the narrow rule like a statute, treating it as being binding in the DIFC. Now, I say that's just wrong as a matter of law in England and Wales, but it would seem even stranger to roll it on and apply it to DIFC rather than the DIFC stepping back and considering for itself how the public policy considerations would play out in a case such as this. And relatedly, which is a point that Your Honour made quite a long time ago this morning, relatedly, the rest of this case is going to trial in any event, going to a long trial in any event, 8 to 10 weeks plus a judicial reading week, and issues in relation to the DIFSA investigation, the decision notices are likely to be in play and form part of the facts of that trial anyway. Indeed, there was a suggestion by Mr. Fenwick that what he would term the wider rule in Graham Thames trains is going to be live in relation to other losses at trial. So this is all going to be being debated at a trial anyway. It just doesn't make sense as a matter of judicial decision making and sensible case management to hive off something as difficult and complex as this and deal with it on an interim basis. So I hope that's a useful taster of
yes, that's a teaser perhaps. All right. Well, unless there's anything else, Ms. Hull, this might be a convenient point to adjourn for the day. And we'll resume again tomorrow at the same time, which I think is 11 a.m. in Dubai, 7 a.m. in London.
Certainly.
All right. Okay. Well, I'll thank you, gentlemen. I'll see, and whoever else is on the line, thank you. I'll see you all again tomorrow.
Thank you.
Good to adjourn. Thank you.
Thank you.